Without objection, so ordered. We'll now proceed with opening statements. I wish you all a good morning and welcome to the fourth hearing of the Economic Development, Public Buildings, and Emergency Management Subcommittee. One of the purposes of this committee is to protect taxpayer dollars by ensuring that they're spent effectively, efficiently, and with transparency. That brings us to today's hearing, which is entitled Landlord and Tenant, the Trump Administration's Oversight of the Trump International Hotel Lease. You can tell from the title that today we're going to be investigating a fairly unprecedented situation. The federal government owns the building that houses President Trump's D.C. hotel. Since President Trump has declined to divest from his businesses, he's essentially acting as both the landlord and the tenant. Before I was elected to Congress, I spent over 3 decades teaching college students about American government and politics. In those classrooms, we had serious discussions about the role of the legislature holding the executive branch accountable to the highest legal and ethical standards, and that's exactly what we hope to do today. So first, let's start with some facts. 1, all federal workers and federally elected officials take an oath to uphold the U.S. Constitution. And of course, that includes the president, all members of the administration, and all of us in Congress. Second, the Constitution contains 2 clauses that are pertinent to our topic today. One prevents an elected official from receiving, and I quote, any present or emolument from any king, prince, or foreign state without the consent of Congress. To date, Congress has given this president no such consent. A second and related clause prevents the president from accepting any federal or state taxpayer dollars or emoluments beyond his presidential salary. Now, a lot of people may not be familiar with the term emolument, but the Founding Fathers thought of it broadly as any payment or benefit. They included it in the Constitution to prevent U.S. government officials from accepting bribes from foreign governments or from parts of our own government that might be trying to curry favor. I hope we can all at least agree that that's a practice that the public and the members of this Congress don't abide. Third, the government lease for Trump's D.C. hotel explicitly states that the tenant may not use the premises to violate federal law, quote again, for any purpose or in any way, and that, of course, includes the Constitution. Moreover, Section 37.19 of the lease states that no elected official of the government of the United States shall be admitted to any share or part of this lease or to any benefit that may arise therefrom. Yet the president continues to have a personal stake in the hotel. When people stay at Trump's D.C. hotel, he directly benefits. Yet despite all the legal and ethical issues that arise from this unprecedented situation, the agency that oversees the lease, the General Services Administration, has not done a thing about it. In fact, the agency's independent inspector general, who is here with us today, conducted an exhaustive report that found that the GSA recognized that the president's business interest in the old post office lease raised issues under the Constitution's emoluments clause that might cause a breach of lease. Despite this observation, the inspector general found that the GSA decided not to address those obvious issues. The inspector general called that improper. Well, I think that's kind of the least of it. When you take an oath to uphold the Constitution, you're bound by that oath. Yet GSA officials have turned a blind eye to these legal and ethical issues. When called on it, the GSA failed to implement basic recommendations made by the inspector general. GSA was instructed to conduct a formal legal review that includes consideration of the Constitution's emoluments clauses and the terms of the lease. As far as I know, GSA hasn't even pretended to conduct that review. GSA was also instructed to revise the language of their leases to make it even clearer that the Constitution is relevant. They haven't done so in any way that satisfies the Inspector General, and they haven't done so in any way that satisfies this committee. Finally, in addition to the legal issues, GSA has refused to turn over documents to this subcommittee, which has the jurisdiction over GSA and that we have a legitimate purpose to examine. In 2008, Congress directed GSA to lease out the old post office building in order to make a profit. Yet GSA, relying on the opinion not of their attorneys, but of the Trump's business lawyers, refused to turn over any basic financial documents that could help us determine if they are upholding the terms of the lease. How can we know that taxpayers' investments are being protected if we can't examine the financial records of the hotel? And how can we ensure that national policy is not being swayed by those spending money at the hotel that benefits people at the highest levels of our government? GSA is also preventing us from looking at legal memos that were drafted when government officials who were supposed to enforce the terms of this lease decided to look the other way. It's shameful, and yet it's what we've come to expect from an executive branch that continues to stonewall Congress and rejects transparency at every turn. Few could have ever imagined a situation like we're in today, but the Founding Fathers were wise enough to put the Emoluments Clause right in the Constitution, and we should be wise enough to enforce it. In our first panel today, we will hear from the agency that oversees the D.C. Trump Hotel lease and from the Inspector General, who found that the GSA did not fulfill its obligations under the Constitution. In the second panel, we'll hear from legal scholars who can shed more light on some of these pertinent issues. I want to thank the witnesses for being here today. I look forward to hearing your testimony and answering our questions, and I now recognize the ranking member, Mr. Meadows, for an opening statement.
Thank you, Chairwoman Titus. Once again, here we are in the drama of everything related to President Trump is bad. You know, instead of focusing on critical issues like disaster recovery, our crumbling infrastructure, we're here today trying to answer a constitutional question that's currently before the courts, and I would offer that no one on this dais is even able to answer. We're looking at a constitutional question, but no, this is all about the president and his business, and we have other business before this subcommittee that is critical to the American taxpayer. We have 79 bills that have been referred to this subcommittee. We've only acted on 9 of them. We could be in a hearing today examining some of those proposals. And it's National Preparedness Month. Here we are. The original plan for this hearing today was to focus on recovery areas, some that affect my very state. But instead, we're here focusing on an issue because of the perception of wrongdoing. Now, based on our markup last week, the remarks by members at the markup, I'm sure that there are members on both sides of the aisle that would view it as a critical responsibility of this committee to address disaster relief. Right now, more than half the states and territories are still impacted by 73 open major disasters and emergency declarations. Additionally, GSA spends over $5 billion a year on leased space. The Federal Buildings Fund struggles to pay for the basic maintenance of those buildings. And yet, here we are today, calling the GSA Buildings Commissioner here not to talk about those important things, but rather to make opine on a decision that's already been made, a conclusion that's already been made by my colleagues opposite. Let us be very clear. We are here today because of a lease that was endorsed by, advocated by Democrats, signed off on by Democrats, negotiated and executed under President Barack Obama, and a lease where nearly all the decisions were made before and after the election were made by the Obama administration. And yet somehow it's the president's fault. And this one decision made after the president was sworn in was done by a career public servant. So even with that, if you focus just on that, we've got a long-term career public servant with leadership that's appointed by GSA making decisions. And here we are today, the Inspector General still found that there was no undue influence in that decision. Now, I'm just at a loss for words almost when you look at this, because GSA has produced documents at the request of members, over 10,000 pages, nearly 3,800 documents that have been produced to the OPO, and more is expected. Yet our colleagues would argue that the GSA is not responding to their requests. So let me be clear on this as well. I'm a strong supporter of transparency and oversight and access to information. But when those demands start taking on outsides beyond the mission, core mission of what is happening, we have the responsibility to make sure that those requests are not only reasonable and legitimate, but they're not just a fishing expedition. You know, Republican members, and myself included, sent a letter in February requesting documents on which the OIG based their analysis and conclusion in her report. That was actually request not as a fishing expedition because of the unusual nature of the OIG's report. The report itself has been cited as authority in pending legal cases, yet contains assertions without citation, and in at least one instance, is factually incorrect. The factual assertion has been disputed by legal experts. You know, it contains its own legal analysis on unsettled constitutional questions currently before the courts. Now, the chairwoman, she has talked about those constitutionally protected areas and our rights of oversight as a legislative body. Indeed it is. This question is one that has to be resolved by the courts, not by the legislative body. If we want to change the law and make sure that we can change it, let's go ahead and introduce something. But to date, nothing has been introduced. No markups on that. Given this issue and the facts using the legal proceedings, it's critical for us to verify every bit of the OIG's report and its accuracy. And to understand the basis of that report, we've requested that the case file document, similar to the request the committee made last year for the OIG's report on the FBI headquarters. However, so far on that, we've only received 177 documents. Those are largely publicly available legal research documents, like law-reviewed articles that they use for the constitutional analysis. To me, that is unresponsive. I hope we can get back to the real work. I hope that we can make sure that once again this committee operates in a bipartisan fashion. Today's hearing is certainly not that, and with that, I yield back.
I thank the ranking member, and I now recognize the chairman of the T&I committee, who has spent some time working on this issue and is quite familiar with the documents that have been released and some of the players and all of the issues. I recognize the ranking member, Mr. DeFazio.
It's nearly 3 years since I first questioned GSA regarding the lease. It's pretty simple. No member, delegate to Congress, or elected official of the government of the United States or government of the District of Columbia shall be admitted to any share, part of this lease, or to any benefit that may arise therefrom. Now, the ranking member just went on at some length about why are we here. We're here because President Trump, ignoring all precedent, decided not to divest himself of his business interests, and in particular, of the hotel, the Trump Hotel, and in particular, a hotel which has a lease that so it says no elected official shall benefit, and the president was elected. I mean, he didn't get a majority of the vote, but he was elected. So to say that this committee should not be pursuing this with GSA in that instance is bizarre. Secondly, this building was leased because it was losing money. And the idea was it's going to make money and we will get a share. Now, you got to question the way GSA does this stuff. They do a lot of things that are incompetent. A share of the profits as opposed to a share of the gross, because you can always hide and come up with, oh, we hardly are profitable. We don't even know today. The only statements we have were either intentionally or unintentionally put online. Now, they would say, this is back in 16. Now, they would say that this is proprietary. If you read through it, these are like simple one-line disclosures. There's nothing proprietary in this document. But now, GSA says, Congress is not entitled to those. Those were released mistakenly. Well, how do we know what the income is? How do we know how GSA is calculating the profits. Apparently, that's the discretion of the contracting officer. I think that's the career official that he referred to. This career official opined in November of 16 that it was absurd that anybody would question this lease or the emoluments clause. This is a contracting officer. And I asked a series of questions of a former official from this agency. Is this how contracting officers work? And then he went on in the email, this was to Ivanka Trump, to say, I want to get together with you and drink some coffee and tell you about my great trip to New York. Now, this is a public servant who's looking out after the public interest. He's still the contracting officer. He has discretion in how they calculate the profits. And we don't know whether we're getting a damn penny out of this thing or not. Here's the statements they give to us. That's it. It's a cover page. A cover page. That's what Congress is entitled to. Well, how much? What's the income? We don't know. What's the profit? We don't know. What's the government getting? We don't know. And the gentleman doesn't want to know whether the taxpayers are getting ripped off or not. That's just extraordinary to me. Extraordinary.
Will the gentleman yield?
I will continue.
Will the gentleman
please.
yield?
No, I will not yield.
Well, you ask
will
a
not
question
yield.
of.
Gentlemen, I will not yield. Please be quiet. You went over time. I don't want to go too much over time. We got a lot
Well, the
of
chairman went
questions
over time too.
Yeah, I haven't gone over yet, but you're going to make me. So, and then I asked for the legal opinions. We can't see them. We can't have them. Okay, so we can't see the legal opinions that have been questioned by the IG, but the gentleman knows that they're fine. The legal opinions, whatever they are.
The gentleman knows that we get $3 million a year from the lease. The gentleman does know that.
We don't know on a monthly basis what the income of the hotel is and what percent, how they're calculating this and what percent we're getting. So we could be.
But the gentleman knows we're getting more money under this lease than the previous lease.
The gentleman is out of order. Thank you, Madam Chair. So
You're not the chairman.
Now
You're not the chairman.
Will the ranking member please stop interrupting?
You can be quiet now? Thank you. So here's the legal opinion that we've recently received from GSA. Didn't come from the council. We've never seen a document out of the general counsel's office. There is a general counsel's office. And it's a document from Michael Best and Frederick, LLP, attorneys at law. And this is the only legal opinion we have, and that happens to be the Trump Hotel's attorneys. This whole thing is so out of line in terms of GSA's oversight of the public interest of the lease of this hotel from day one. Day one. And that's why we're here today. And we're here principally because this president failed to divest himself of conflicts of interest and put himself and exposed himself not only in violation of the lease, but also to the emoluments clause of the Constitution of the United States, both foreign and domestic. That's why we're here today. Right on time.
Thank you. The chair now recognizes the ranking member of the T&I committee, Mr. Graves, for an opening statement.
Thank you, Madam Chair. Ranking Member Meadows. You know, we used to hear over and over and over again when Republicans were in the majority, why aren't we doing infrastructure? Why aren't we doing infrastructure? Where's an infrastructure bill? And that question's still valid today, and yet here we are in a politically motivated hearing talking about the old post office. You know, in light of the disasters this year, I think we should be focusing on making sure our community's disaster reform efforts are working instead. Instead, here we are again in a politically motivated hearing. We need to make sure our communities have the tools to prepare and recover from the next disaster. You know, we saw just last week parts of Texas being hammered by Tropical Storm Melda. My home district in Missouri is still recovering from historic flooding with devastated homes and farms and people that still haven't been able to get back into their houses. You know, we have many communities that have a long way to go when it comes to recovering from the last two hurricane seasons. And instead, today's hearing is going to be nothing more than a political spectacle and a chance for the president's opponents to try to undermine him and continue to do their search for anything to further their case on impeachment. And that's what this is about. You know, instead of working on disaster preparedness or any other of the countless number of infrastructure items that are clearly more important than this, like fixing roads and bridges, we're instead going to be listening to politically motivated criticisms of the president. I know we have We've worked together in a bipartisan manner on this committee, and I believe we can still do that if we put politics aside. But instead, this is a political distraction. It takes us away from the important work that this committee should be doing. And with that, I yield back.
Thank you, Mr. Graves. At this time, we'd like to welcome our witnesses. On the first panel, we have Mr. Daniel Matthews, the Public Building Commissioner for the U.S. GSA, and we have the Honorable Carol Ochoa. Thank you for being here. We look forward to your testimony. Without objection, our witnesses' full statements will be included in the record. Since your written testimony has been made part of the record, subcommittee requests that you limit your oral testimony to 5 minutes as well. At this point, we'll begin with Mr. Matthews.
Good morning, Chairwoman Titus, Ranking Member Meadows, and members of the subcommittee. My name is Dan Matthews, and I was sworn in as Commissioner of the Public Building Service in August of 2017. Before that, I served as the Majority and Minority Staff Director of this subcommittee for almost 15 years. Let me begin by thanking you for authorizing our prospectuses and for your help in securing Senate authorization as well, particularly for the Lloyd George U.S. Courthouse in Las Vegas. I also would like to briefly discuss how PBS is attacking some of the most difficult challenges in federal real estate, which this committee and the GAO identified over the last decade. These problems include an over-reliance on costly leases, the need to renovate our aging inventory, and to reform the courthouse construction program. Since September 2017, GSA has cut 3.5 million square feet from its expiring lease portfolio, negotiated rental rates 11% below market as compared to the historic average of 3 to 5% below market, and avoided $1.9 billion in future lease costs. By investing our scarce capital in GSA-owned facilities, such as the Suitland Federal Center in Maryland, GSA is reducing our reliance on leasing and improving the quality and utilization of our most important facilities. And finally, GSA is partnering with the judiciary to construct over $1 billion in courthouses on budget and on schedule. Over the last 2 years, GSA has made significant progress in addressing the bipartisan priorities of this committee, and I look forward to working with you on these issues in the future. Moving on to today's topic, I would like to share some context I believe is important. One of the long-standing bipartisan priorities of this committee was to address the serious disrepair and occupancy problems at the old post office. This effort resulted in the bipartisan enactment of the Old Post Office Building Redevelopment Act, which directed GSA to redevelop the old post office while maintaining federal ownership and the historic integrity of the facility. Pursuant to the act, GSA conducted a full and open competition, and in 2013, signed a 60-year lease with the Trump Old Post Office, LLC. The company pays rent, and the lease provides for the potential of revenue sharing with the GSA and the American taxpayer. This joint effort created a substantial financial benefit for the government and taxpayers. Prior to the redevelopment of the old post office, GSA operated the facility at a significant annual loss, including $6.5 million in 2007 alone. Today, as a direct result of the act, instead of a multi-million-dollar operating loss, GSA now receives approximately $3 million in annual rent for a historic property that has been fully renovated with private funds. While the Inspector General's review of the old post office outlease did not seek to determine whether the President's interest in the hotel violates either the emoluments clauses or Section 3719 of the lease, both of these issues continue to generate questions from members of Congress. With respect to the emoluments clauses, it would be inappropriate for GSA to weigh in on that issue while it is the subject of active litigations. The first of several lawsuits alleging violations of the emoluments clauses was filed on January 23, 2017. Accordingly, the meaning and application of the emoluments clauses has been the subject of active litigation for the entirety of the administration. Beginning in June of 2017, the Department of Justice has taken the position in those cases that the President's interest in the Trump International Hotel does not violate the Constitution. The committee can rest assured that if and when these issues are conclusively resolved as a matter of law, GSA would faithfully adhere to those legal determinations. With respect to Section 37.19 of the lease, GSA followed its standard process for determining compliance with the terms and conditions of a lease. The career contracting officer, who has the legal authority and responsibility for making contract decisions, worked in consultation with the career attorneys from GSA's Office of General Counsel to make this decision. As a result of that process, in a March 27 determination by the career contracting officer, GSA found the tenant in compliance with Section 37.19 of the lease. As the committee is aware, following the contracting officer's determination, The GSA's Inspector General conducted a 16-month investigation into the management and administration of the old post office building lease. Given the title of this hearing, I believe one key aspect of the review is absolutely vital to reiterate. The Inspector General found no instances of undue influence or interference on the career civil servants charged with administering this lease. Furthermore, as noted in our response to the review, GSA agreed with the report's single recommendation as the agency understood it and will take action with that recommendation, consistent with that recommendation, prior to continuing to use the language in future outleases. Lastly, GSA has worked diligently to respond to congressional oversight requests concerning this project, including requests from this committee. As part of this effort, GSA has provided more than 3,000 documents and 10,000 pages of materials in response to this committee's requests, in addition to numerous briefings on this topic. In conclusion, again, let me thank you for authorizing our prospectuses in a timely manner. We very much appreciate that. Thank you.
Thank you, Mr. Meadows. We appreciate you getting your testimony to us ahead of time, which was late last night, despite the deadline being earlier. Ms. Okoa?
Good morning, Chairman Titus, Ranking Member Meadows, and members of the subcommittee. Thank you for the opportunity to testify here today regarding the Office of Inspector General's evaluation of GSA's management and administration of the old post office.
I'm sorry, would you hold the mic closer so we can hear you better?
Sure. As you know, GSA administers and manages the ground lease for the old post office building on Pennsylvania Avenue in Washington, D.C. The Trump Old Post Office LLC is the tenant on the lease. On July 28, 2017, my office initiated an evaluation of GSA's management and administration of the lease based on numerous complaints from members of Congress and the public. We focused our evaluation on GSA's decision-making process for determining whether the President's business interest in the lease caused the tenant to be in breach of the lease upon the President's inauguration. We did not seek to determine whether the President's interest in the hotel violates either the emoluments clauses of the U.S. Constitution or the interested parties provision in Section 3719 of the lease, or whether any violation caused a breach of the terms and conditions of the lease. Rather, we sought to determine whether there were any improprieties in GSA's decision-making process regarding those issues. Our evaluation found that GSA, through its Office of General Counsel and its Public Building Service, recognized that the President's interest in the lease raised issues under the Constitution's emoluments clauses that might cause a breach of the lease, but decided not to address those issues. We found that GSA attorneys made the decision not to address these issues by mid-December 2016, after having been put on notice in the summer of 2016 of the President's status as a nominee of a major political party for the presidency. The attorneys did so without preparing a decision memorandum to document the rationale for the position they were taking. They did so without conducting any research of the two emoluments clauses. They did so without checking for any opinions about them from the Department of Justice Office of Legal Counsel or contacting or seeking guidance from that office. Our report found that GSA was correct in recognizing that there was a potential issue regarding the old post office lease, raising constitutional issues. We addressed GSA's reasons for ignoring the constitutional issues and the effect this had on its analysis of Section 3719 of the lease. GSA's lawyers gave us various reasons for their decisions to ignore the emoluments clauses. They told us, for example, that constitutional issues rarely arise in GSA's work, that the emoluments clauses are not within GSA's purview, and that GSA's role is only to opine on specific provisions of the lease. For reasons that we set out in the report, we rejected these explanations. We rejected them largely because the decision to include the emoluments issues from GSA's consideration of the lease was improper because GSA, like all government agencies, has an obligation to uphold and enforce the Constitution, and because the lease itself requires that consideration. In addition, we found that GSA's unwillingness to address the constitutional issues affected its analysis of Section 3719 of the lease. That led to GSA's conclusion that tenants' business structures satisfied the terms and conditions of the lease, and as a result, GSA foreclosed an early resolution of the issues, including a possible solution that would have been satisfactory to all parties, and the uncertainty over the lease remains unresolved. At the conclusion of our report, we recommended that before continuing to use the language, GSA determine the purpose of the interested parties provision, conduct a formal legal review by its Office of General Counsel that includes consideration of the foreign and presidential emoluments clauses, and revise the language to avoid ambiguity. I very much appreciate the interest of the committee in the work of our office, and I'm happy to answer any questions you might have.
Madam Chairman, I have a unanimous consent request.
Gentleman's recognized.
I thank the gentlewoman. In light of the testimony indicating that there was a $6 million annual loss that Mr. Matthews had, I would ask to be entered into the record both a briefing and a part of the lease that would indicate a base rent of $3 million, which would be income to the U.S. government, not an expense. Ask these documents be entered into the record.
Without objection.
Thank you.
Thank you. Now, thank you both for your testimony. We'll now move on to member questions. Each member will be recognized for 5 minutes, and I'll start by recognizing myself. Mr. Matthews, before you accepted your current job in the summer of 2017, did anyone affiliated with the Trump administration, Trump transition team, Trump campaign, or Trump organization ask you for your opinion on whether the Trump organization was in violation of the lease for the old post office?
I had no communication with anyone from the Trump companies while I was being considered for this position. No.
Have you ever had any communication with any current or former GSA employees about how the White House or President Trump would respond if he were forced to divest from his business interests?
Well, I worked for this subcommittee as the majority staff director, and we certainly received briefings from GSA on this very question.
Thank you. Ms. Okoa, in January of this year, your office issued a report that's been described that outlined the failures of the GSA to address the issues with the lease, including those that pertain to the emoluments clause. Is that correct? And on March 29th of 2019, GSA delivered a corrective action plan to you in response to the recommendations of how they should remedy the issues with the hotel lease. Is that correct? And did you find that GSA's plan to remedy the situation was sufficient?
We have not agreed with the agency's corrective action plan to date.
And in your judgment, did GSA adequately clarify the section of the old post office lease that prohibits elected officials from being a party or beneficiary of a federal lease?
It's my understanding that GSA has not undertaken the analysis we requested.
Did GSA bother to do the legal review of the emoluments clauses that they failed to do when Donald Trump took office and that you recommended?
I have no information that they've done that.
So GSA went back, and is it correct they submitted another plan to you on August 26th of 2019? Is that correct?
I think that's the right date.
And did your office find that their plan to remedy the situation on that day was significantly different from the one that they'd submitted back in March?
No, it is not.
I've got the two documents here. The first is the GSA's corrective action plan dated March 29th, and the second is Inspector General's communication with the GSA on September 6, 2019. I'd ask for unanimous consent that they be entered into the record. Without objection, so ordered. Section 3719 of the lease states that no member or delegate to Congress or elected official of the government of the U.S. shall be admitted to any share or part of this lease or to any benefit that may arise therefrom. Ms. Okoa, your agency said that the GSA needed to clarify this language. Is it true that GSA attempted to clarify this language by claiming that it should only apply to members of Congress and not the President of the United States?
The corrective action plan proposes to drop the language from Section 3719 that prohibits both state and local elected officials and the president and vice president from benefiting from the lease.
So their way of dealing with the problem of the president coming under the emoluments clause was to drop the president from the lease and just say that in the future this would apply only to members of Congress, but not the president and the vice president. Is that correct?
Or state and local elected officials.
For both clauses then, yeah.
That's my understanding of their corrective action plan as to Section 3719.
I find that astounding. And on top of that, is it correct that to date GSA has still, in your judgment, failed to uphold its constitutional obligation by conducting the legal review of the emoluments clauses?
Yes, I am not aware of their effort to look into the emoluments clause in connection with how it affects interpretation of Section 3719.
Mr. Matthews, I'm sure we're in agreement that the President of the United States is an elected official of the government. Given that the agency's independent IG has just said that you failed to uphold your duties under the U.S. Constitution, can you commit that the GSA will conduct a legal review of the emoluments clause as they pertain to the Trump D.C. hotel?
I guess first I'd like to just respond to our corrective action plan. So with respect to the interested parties provision, GSA agreed to no longer use the language contained in Section 37.9 in future outleases, not in the current lease, in future outleases. So I just wanted to correct that.
So in future leases, only Congress is
implication
prohibited,
that
but
we
not
were-
the president and the
we were
vice
cutting that
president, in
out,
case there are
that's
future
not-
leases. We got that.
correct.
Now, will you conduct that study of the legal implications or legal review of the emoluments clause?
So on that question, what we propose to do in future outleases is to remove the ambiguity from that interested parties clause by striking it and referencing the statutory basis for that clause. So there's a direct reference to that statutory reference. That's what we're proposing to
That
do.
statutory reference does not supersede the Constitution. So it seems to me that the IG's investigation revealed that y'all just completely ignored the serious legal and ethical questions here. And your response to their recommendations was not to follow the recommendations, but to strike the president and the vice president and say, oh, that just applies to Congress. Thank you, and my time is up. Mr. Meadows? Oh, Ms. Miller would be recognized.
Thank you, Chairwoman Titus, and thank you, Ranking Member Meadows. I spend most of my time on the Oversight Committee in hearings designed by my colleagues across the aisle with only one goal: to impugn and impeach our president. And now, instead of being productive in this committee, we are subjected to another display of political theater. And listen to what the left thinks about what the president is doing with a hotel that he's not involved with. Here I am in a Transportation and Infrastructure Subcommittee meeting. It's one of the most bipartisan committees in Congress, and we're doing it again. This is disappointing. I find it disturbing and a waste of the American people's time and dollars. I came to Congress to work on issues that matter. Infrastructure is the future of America and the future of our states and my home state of West Virginia. When this hearing was first noticed, it was supposed to be a disaster recovery hearing. Again, an issue that is very important to my home state and many of the other states that are suffering. It's an issue that I want to work on. It is sad that the political environment is so toxic that it is preventing us from doing what we came here to do, which was to work together on things that matter. Mr. Matthews, isn't it true that before the lease that we were losing $6 million per year on the old post office and that now the taxpayer is actually receiving income?
Yes, that's correct. We have essentially a $10 million swing in the operating revenues of that facility. It's been a tremendously successful project, a bipartisan project from a real estate perspective and a financial perspective from the taxpayer. We also have a building that had approximately $200 million in unfunded capital repair requirements. It's been fully renovated, all the mechanical, electrical, plumbing, you name it. It's all brand new. The building's being maintained to a high standard. It's a very successful real estate project for the taxpayer.
On what date did the GSA announce the selection of the Trump Organization as the preferred developer for the old post office building?
The lease was executed on August 5th, 2013.
And when was it signed?
That's when it was signed, ma'am.
Okay.
August 5th, 2013.
And on what date did the president alert the GSA that he intended to alter the business structure to assign his interest to another party in order to comply with the lease?
I believe that took place, I'd have to check to get that exact date. I'm afraid it's not on my timeline, but I believe it was either early 2017 or late 2016.
I'd like to know when it's finalized. Was that before or after his official inauguration?
Again, that was January 23rd, so I'd have to get that specific date, but it was right around that time.
Okay. At what date was it determined, following the review of the lease, that the tenant was in full compliance and when in effect?
That was March 23rd, 2017.
Thank you. I yield back my time.
The gentlelady leaves back. I'd like to make a clarification. I don't know where this is coming from, that the hearing was noticed for some disaster relief. This hearing has been noticed for this topic all along, and so that's something that needs to be cleared up.
Yeah, Madam Chairman, I think what it was on when we had the subcommittee looking at proposed hearings, you noticed it one way, but when we were doing the hold date, it was hold for disaster relief. I think that's where the ambiguity is.
And I think that is scheduled for later next week. We'll be looking at FEMA again.
I have a unanimous consent request. Madam Chairman, I would ask unanimous consent that these three photos be entered into the record that show the delegate from D.C., the mayor of D.C., along with President Trump at the groundbreaking, along with the celebration at the ribbon cutting with the delegate from D.C., trying to demonstrate how everyone seemed to be happy about this until the president was elected.
Without objection, we'll enter these into the record. Ms. Norton, you're looking good here, and I would point out this is prior to the president being elected, which changes
I
the
would
situation.
point out one of the photos for the record is
Return to the
after
topic at hand,
Okay.
well, to my knowledge, just a point of clarification to make clear on the unanimous consent request is that one of the pictures is actually after the opening of the Trump Hotel.
Who cares?
Would the
Could
gentleman?
I please have?
Can we have a little
return to
order
the
in here,
hearing?
please? Can we please have a little order? This is,
No objection.
all right. There was no objection to entering these into the record. We just want to be clear that this is at the lease signing, which is prior to Mr. Trump being inaugurated as president. All right, prior to him being president. We'll now recognize Mr. DeFazio for 5 minutes.
Thank you, Madam Chair. You keep referring to the income, which is actually mandated by the lease, and all you're talking about is the mandated rent payment. And there is a provision of the proposed lease, percentage rent difference, where, and I would again question GSA's judgment in how they calculate this, but that we are supposed to receive an additional amount of money if the property is profitable. And according to these, the only released monthly statements that were leaked or intentionally put out by a public-spirited employee at GSA, it began to be profitable in February 2017. So, Mr. Matthews, last year, all you're quoting to us is the rent payment. What was the additional amount paid to the GSA under the terms of the lease out of the profits of the Trump Hotel?
Thank you for the question.
It's a simple question. Just give me the number.
So I actually need to correct something. The profit sharing is not based on profits. It's based on gross revenues.
Okay, good.
And those gross revenues are reported.
Okay, so what was the amount? I'm asking you a simple question. We do not have that number. You've not provided us that number. What additional payments were made to the government last year under this lease beyond the mandated rent? How much?
We receive, and the way it's structured is it's based on gross revenues with a minimum payment of approximately $3 million and a maximum payment. It's a percentage of the gross revenues.
3% more, up to 3%.
It escalates every
Okay,
decade.
all right. So how much did we receive last year over and above the mandated rent?
As I testify, we received the approximately $3 million base rent.
So, okay, so all we got was the base rent, so you're saying this hotel is losing money?
I'm not saying.
No one's staying there? There's no gross revenues, there's no sharing, it's not beyond the lease? The rent? Okay, so you're telling us that. Do you believe it's legitimate for this committee? You worked this committee for a long time.
Yes, I did.
Do you believe we have oversight responsibility?
Yes, I do.
Good. Now, then why can't we get anything except redacted monthly statements? How do we know, and you can't give me a number, that we're getting the additional payments that are required under the lease if you won't give us any financials? Will you give us the financial statements?
So,
Will you give us yes or no?
so our goal.
Yes or no?
Our goal is to.
Yes or no?
Our goal.
Yes or no? Okay, you're not going to answer that question. Okay. You were asked earlier about so you're not going to provide those. How about doing an audit? You do audits of leases, is that correct? Yes or no?
We receive an annual audited financial statement.
Who audits it?
It's a third party, and we receive an annual.
Okay, did you
audit
choose the
statement.
third party?
Excuse me?
Who chose the third party?
The tenant provides the.
Sure, okay,
Audited
good.
financial statement.
Okay. So you don't feel you have any responsibility to check into that, or the contracting officer doesn't?
That
And
actually.
to oversee. To the IG, would you conduct an audit of this hotel to see whether or not the income which is required over and above the base rent is being properly paid to the taxpayers of the United States of America?
Actually, GSA has specific authority under the lease to conduct such an audit. It's
Well, he just said they
5.4
won't
of the
do it.
lease. The focus of that audit would be on determining whether the government is getting the appropriate rent payments.
Yes.
We'd have to think about that. We certainly have oversight authority over the payment issue. We'd have to think carefully about the resources that it would take to do such an audit and any constraints on our ability to get the records independently of GSA. We'd have to think about whether it made sense for GSA to ask us to do that audit or to have an outside auditor with expertise in
But
hotel.
GSA has the authority. GSA has done this for other leases, I would assume. Have you? Have you ever audited a lease? GSA ever audited a lease, or do we let all of our tenants just send us their own financials and send us their own legal, after they've hired an accountant?
I don't know offhand if we've audited other leases, but
Okay.
we do receive certified financial statements.
Right, okay. So since you received them,
They,
how much additional money beyond the base rent did we get last year, did the taxpayers of the United States of America get last year under the terms of this lease? What was that number?
we just received the base rent.
Okay, so somehow you've calculated that, within this whole purview, there's no one staying there, there's no revenues over and above.
Well, again, we receive certified annual financial statements that tell us what the gross revenue is, and we know that we are receiving the proper amount of rent.
Okay, I thank the gentleman.
We now recognize Mr. Pence.
Thank you, Chairwoman Titus, Ranking Member Meadows, and the witnesses before us today. Ranking Member Meadows, I know you want to save taxpayers billions of dollars in the public building space. Like, it seems like we've saved $9 million a year here at the Trump Hotel. And I'd sincerely like to thank you for your leadership on this issue. I would like to take this opportunity to discuss real issues that impact Hoosiers and all Americans, like transforming how we approach federal real estate and saving taxpayer dollars instead of putting on a partisan show. You see, billions of taxpayer dollars can be saved if we continue to, 1, consolidate and reduce our space footprint, 2, negotiate good lease deals, 3, sell or redevelop properties that are underutilized and high value, and 4, put people in more efficient buildings. Commissioner Matthews, when we met back in April, you told me that I told you that I had 2 priorities: public-private partnerships, and updating OMB's SCORE rules to bring our approach to federal real estate to the 21st century. If we are serious about transforming how we approach federal real estate, it is critical for us to do things differently and put more options on the table, like P3s. Today, Mr. Meadows and I introduce a Public-Private Partnership for Prosperity Act of 2019, legislation to provide GSA with flexibility to pilot the use of public-private partnerships. Hopefully, we get back to doing the work for the people we represent instead of grandstanding and self-promoting. I yield back.
Thank you, Mr. Pence. We'll now recognize Ms. Davids.
Thank you, Chairwoman. Mr. Matthews, in light of the Inspector General's finding that the result of the that as a result of GSA's failure to address the constitutional issues raised by the lease in question, has GSA taken any steps to address the emoluments and other constitutional issues at all?
So a couple of points on that. One, so we agreed with the single recommendation of the report, and as we understood it, and we are applying a new to future out leases. We've agreed to remove the interested parties provision and replace it with a reference to the underlying statute that is that governs that provision to remove any ambiguity.
Sir,
from
that's
that provision.
actually, that's not the question I asked. I didn't ask what you were doing moving forward on other leases. I asked about the lease in question.
So the lease in question, there are a number of lawsuits that are pending that are specifically designed to address this question of is there or is there not an emoluments violation. In that forum, the Department of Justice speaks for the executive branch of government, and the Department of Justice has argued before the courts there is no emoluments violation, there is no violation of the Constitution, and it would not be appropriate for GSA to opine on that matter, given that the courts are addressing that issue. The Department of Justice has
thank you.
spoken on it.
That's enough on that one. So in response to a question that was just asked, you said you were uncertain whether you've conducted any audits on leases that the GSA has entered into. Is that true? You don't know whether you've...
So
So you're currently running the GSA, is that right?
I'm the Public Buildings Commissioner, that's correct.
Okay, and you don't know if your agency conducts audits on leases?
We have thousands of leases. We conduct a variety of contractual lease administration activities every day.
And you're unsure if
they
an audit
involve
is one of those
third-party
activities?
audits, I couldn't tell you, but we enforce contract actions every day.
Sir, I would like you, after
Thousands of
this
them
concludes,
every day.
to submit for the record whether or not the GSA conducts audits on any leases that it enters into.
We'd be happy to,
Thank you.
to get back to you on that.
What percentage of the activities that your agency, that you are responsible for right now for the American people, what percentage of those activities is managing leases?
So we have about $10.5 billion flowing through the Federal Buildings Fund, over 8,000 leases, approximately $5.6 billion in annual rent expenditures for private sector leases. It's the majority of our portfolio. It's one of our top priorities.
That is a lot of money to not know whether or not you audit the activities. Are you concerned about the fact that you may or may not be auditing $10+ billion annual funds that go to the federal government?
We have program management reviews on a regular basis. We have contracting reviews on a regular basis. We have a whole office within GSA. It's outside of PBS, but it's called the Special Procurement Executive, Senior Procurement Executive. We do contract reviews of different business lines on a regular basis. Every region, this year alone, we've probably gone through 6 or 7 regions of internal contract reviews of our leasing programs. So there's tremendous oversight over this. The question was about a very specific type of audit. And I don't know if we do that same type of audit across all of our leases. I don't know if those lease terms, frankly, authorizing that type of a specific audit is even present. This is an out lease. Out leases are a very few minority of our lease portfolio. Most of our leases, we are the lessee and we are leasing a facility from a lessor. In this case, it's reversed.
How often do you have a profit-sharing provision in a lease that you enter into as the GSA?
Again, our out leases are relatively
Can you
few in
please,
number.
because it sounds like that will take you a long time to get to, can you please find out how many and then report that to the committee? And then also find out how often you conduct audits on out leases specifically and report that to the committee as well. From the answers that you have given so far, in addition to the lease that we're currently reviewing, I have major concerns about the oversight that you have over any of the leases that the GSA has entered into, because it sounds as if you're not exactly sure what kind of review you're doing, and that is very problematic for the person who is ultimately responsible for the properties that the federal government has. I yield back.
Thank you. The lady yields back, and we'll now recognize Mr. Palmer.
Madam Chairman, I have a point of inquiry before I begin my questions, if I may. And it's a serious, I'm asking for information. In Chairman DeFazio's opening statement, I just need to clarify, did he say that he had a conversation with a former GSA employee who gave him a different perspective on the lease arrangement?
Oh, I said my staff did.
Your staff did. Did that individual provide, Madam Chairman, did that individual provide documentation either in printed or electronic format, or was the content of the conversation recorded?
May I respond to the gentleman? The former ranking staff who has jurisdiction over this issue met with a person from GSA, and that person said there were substantial issues to be resolved. That conversation was characterized and sent to GSA in a letter of inquiry in November, and GSA said that's not the conversation, and they denied the whole thing. So that's the end of that, and that gentleman has been transferred to New York, and he won't talk to anybody.
Okay, but it was a former
He's been
staff.
transferred. He's been transferred to New York, the
Yes,
GSA employee.
Madam Chairman, my inquiry is, was that a former member of this committee staff that had that conversation? And if it was documented in any form, then it should have been provided to the entire committee, the staff were identified and the individual identified. That would be my point of inquiry.
I have no idea what he's talking about.
We'll just take a minute to take that under consideration.
Thank you, Madam Chairman.
I've been advised that it was an informal meeting to a former staffer. I'm sure those kind of meetings take place all the time. We can talk about that further offline.
I thank you, Madam Chairman.
Thank you.
It would be my opinion that that information should have been provided to the entire committee, but I really appreciate your response to the inquiry.
Okay, thank you. You would like to-
Point of order.
Mr. Meadows?
If indeed it is entered into the record, it has to have something that's documented. You can't have a referral to a testimony that is not something of record, according to the committee rules.
This was not a testimony. It was not referred to as a testimony. It was referred to as an informal conversation with a former staff person.
So, point of inquiry then, was it subject to your investigation? So you're saying this is not part of your normal investigation, this was just a casual conversation?
This was back in 2016, so we will move on with the questions from Mr. Palmer.
You mean under the previous Congress?
Yes.
So then it's not relevant to this hearing?
Well, it's as relevant as the pictures from the ribbon cutting are, so I think we'll now move on with Mr. Palmer's questions.
Thank you, Madam Chairman. IG Ochoa, is that correct?
Ochoa.
Ochoa, thank you. In your written testimony, you make a point in your conclusion that appears to say that the procedures that the GSA followed in these out-leases of historic properties is consistent with the other out-leases. And I'll read to you, it says, GSA OGC has acknowledged that if a constitutional violation were later found, they would have to revisit the issue of potential breach of the OPO leases interested parties provision. However, the fact remains that GSA continues to use the language of the provision and other out-leases of historic properties. So it appears to me that they're basically doing what they always do. It's almost like a cut and paste and a lease arrangement that occurred apparently in 2013. Is that accurate?
Are you asking me about the origin of that language?
No, ma'am. I'm asking you if this is consistent with what, as you point out, and it appears that you think it's problematic, GSA has kind of a standard operating procedure for these out leases of historic properties.
The point of the sentence that you're reading to me was that GSA has told us that if there is a constitutional violation found, they would have to go back and revisit whether there was a breach
But the
of
point
the
I'm
old
making-
post office lease. They still have the same language in two existing leases.
It's consistent with the other leases. It's the same language in these other out leases of historic properties.
Yeah, it's substantially similar. The only difference is which state and local officials it applies to.
That's my point. This is a standard lease. Madam Chairman, I yield the balance of my time to the ranking member, Mr. Meadows.
I thank the gentleman from Alabama. Mr. Matthews, let me come to you. Is the Trump organization in breach of their contract?
No, in March 2017, the contracting officer found them in compliance.
All right, and so with regards to the lease payments, are they in breach of their lease agreement on going up until today? Are they paying the accurate amount of lease payments as agreed upon in the lease that we all have?
Correct. They are current on the rent.
In your long history with this committee and with GSA and dealing with public buildings, would it be foolish for them to underpay on their lease because that would, in essence, terminate the lease after all the improvements they've made?
It certainly wouldn't be wise.
Okay, well, let me put it this way. If you had invested millions of dollars to upgrade the old post office, would you make sure that you're making your monthly payments in accordance to the lease so that you do not default on a lease?
One would think it would be important to remain in compliance with the lease, absolutely.
All right, so fundamentally, the question that we have before us today is not whether the Trump organization is making the payments that have been negotiated under the previous administration, as I said in my opening statements. It's not that so this all boils down to an emoluments question and whether the President of the United States should get some kind of benefit tangentially from the operating of a hotel that he leased prior to him becoming president. Is that correct?
Yes, it is. We know we receive. We have a certified annual audited financial statement. We know that the right amount's being paid. And you're right, this, at the end of the day, this comes down to that core question, which is pending before the courts. And GSA is not in a position to opine on that answer. The Department of Justice already has.
Does GSA have a number of buildings in the Washington, D.C. area that they're actually paying money, taxpayer money, out on an annual basis to maintain those buildings that is a net cost to the taxpayer?
There are some, and most of them are historic buildings.
Are there more than a dozen of those?
I don't know about in the
It's
national
a
capital
softball
region,
question.
but certainly nationally, absolutely.
Okay, all right. And so in doing this, what you took was a non-performing asset where we lost, according to your testimony, $6 million a year. Is that correct?
Yes.
And you're now making it a net plus at $3 million a year to the federal treasury. Is that correct?
That's correct. It's been a very successful financial real estate transaction for the taxpayer.
I yield back.
Thank you. Chair now recognizes Ms. Norton.
Well, hooray for us. We don't even know if we're getting the share of the profits that the government is entitled to. The old Post Office Redevelopment Act was my bill. This building is located not only in my district, in the nation's capital. It was an embarrassment to anyone who came. It is catty-corner from the White House. It was a dump. The first floor was used for street vendors, essentially. And so we finally were able to get those taxes. And by the way, they pay that bill. They do pay property taxes to the district and DC hotel tax. You bet your life I was pleased to cut the ribbon on this dump and make it into a real asset for the federal government. It was underperforming, and in plain sight, the government was losing millions of dollars every day. Let me ask you, Commissioner Matthews, you said that the GSA now receives a monthly rent payment, and here I'm quoting the amount you indicated, $267,653 a month. I appreciate that figure. As with any testimony, could you tell us how the Congress can verify your answer? Obviously, we don't take at face value figures like that without having some way to verify them and therefore give credit to such an answer.
Well, so we receive the rent, we receive payments, those go into the U.S. Treasury. We certainly could provide you the financial transaction records that show that those deposits were made. I'm sure that's possible.
Mr. Matthews, but what GSA continues to provide Congress with are monthly and annual financial statements. I made this same request 2 years ago, but we have still not received the monthly financial statements. I'm asking you now at this hearing, will you commit to providing this committee with these financial documents so we can verify that the old post office is a performing asset, as you have indicated today?
So with respect to the financial documents request, I would say our goal is to accommodate the committee's oversight request to the greatest extent possible while ensuring compliance with our contractual obligations to the tenant. And our staffs, I know, are discussing these issues, and we're trying to come to accommodate that request so we can provide information while also respecting our contractual obligations under the lease.
You will engage with the committee on this question of providing the documents I have just asked for?
Our staffs are correct.
What?
Our staffs are correct, yes.
As we speak. All right. Thank you very much, Madam Chair.
Gentlelady yields back. Mr. LaMalfa is recognized.
Well, thank you, Madam Chair, for allowing me to sit on the committee today and ask a couple of questions. As we get into the fall season here, you know, the pumpkins are ripening and people are just going crazy for pumpkin spice coffee, and early birds are putting the witches and ghosts out in their yards. So we're going to chase a few more witches and ghosts, I guess, right? Because I'm in disbelief that we're here at a time with the fires in the West we've had and the hurricanes and the flooding in the South, the infrastructure we should be working on, boosting up our levees and water infrastructure, and everything around this country, that we're dealing with a hotel here once again that has been established as making money after it was losing money for years. And it's getting down to, do we have to ask our accountants, is it in fact making money? I mean, that's pretty simple stuff. Do we want to see the, Mr. Matthews, does the president sign the checks himself? I mean, I have a hat with a signature on it. If you can compare signatures to make sure that's actually happening, do you need that information?
I know the lease is with the Trump Old Post Office LLC, not with the president himself.
Okay, well, that's about what we're down to here. So now, if we want to actually talk about what this committee works on, the Subcommittee on Economic Development, Public Buildings, and Emergency Management, I'd hope we do more emergency management with what we have going on, but we do have a situation of a public building in California. There's a request for a new federal building for the Citizenship and Immigration Service Centers, which process immigration applications. Kind of a big deal right now, right? Their existing building has an extremely high-risk seismic classification and other health issues in the building which have impacted federal workers and has caused delays in processing immigration applications. Again, kind of a big topic these days. So this committee hasn't acted on that. It's done some other business here, but a very high priority issue with our border and the people that, we hear a lot of dramatics about how they're doing along the border. Can you, with the committee not having addressed this, can you talk about the importance of expediting this and the committee do this work?
Yes, I'd say a couple things. Seismic interests are obviously very important. We have an older inventory, so oftentimes our buildings are not to current seismic codes, and so we are in the process of upgrading a number of buildings across the country in high-risk seismic areas, some in California, and some in Oregon, some in Seattle, Washington as well, and then in the New Madrid fault area. And one of our biggest challenges is that our federal buildings fund, we receive about $10.5 billion in rent from our tenant agencies every year, but we only receive appropriation out of that fund about $9 billion to $9.5 billion a year. So every year, we're being shorted about $1 billion and $1.5 billion of funds that can only be spent on public building purposes under Title 40. But the money's sitting there, and we're not able to access it. And properties like you're describing, we're really challenged to repair them, get them in good working order, and to make them safe. We've got thousands of employees sitting in federal buildings that need real significant improvements. And if we had full access to the funds in the Federal Buildings Fund, we'd be able to do that. It's absolutely critical to approve prospectuses in a timely manner. And again, that's why I thank the chairwoman for her help, particularly with a prospectus we had for a building in her district. We have a courthouse. It's about 20 years old in the fire life safety system. We'd proposed that project. And for a good year and a half, that prospectus was sort of blocked up in the Senate. And thank you for your help. We were able to get it loose, and we're now replacing the fire alarm system.
It'd be nice, Mr. Matthews, if we could get that prospectus going here, because we have a backlog at the border. We have obviously many seismic issues in my home state of California and nearby in Oregon as well, and in the West. So would you say this is a priority this committee should take up?
Yes, we'd very much appreciate that.
Okay. Thank you. I should end it there. I'd like to yield the rest of my time to Mr. Meadows. So thank you for that to answer, Mr. Matthews.
I thank the gentleman from California, Ms. Ochoa. Let me come to you. After your report was released, I think Seth Tillman, a lecturer for the Maynooth University Department of Law, wrote you detailing a factual error in your constitutional analysis of the Emoluments Clause. Are you aware of that? Can you hit your...
Asking that we adopt his particular argument.
But pointing out that he felt like you had a factual error.
He expressed a different view.
Well, did he say you were correct?
He expressed a different view.
It's an easy... well, you got counsel behind you if you want to turn around and ask them. I mean, did he agree with your analysis?
No, he did not.
Okay. So I would ask unanimous consent that we enter into the record the statement from Professor Josh Blackman and lecturer Seth Tillman detailing the exchange with Ms. Ochoa's office.
Without objection.
Thank you. yield back.
We'll now recognize Mr. Garamendi.
It wasn't me, John.
Got it. Thank you. No, it certainly wasn't, Mr. Meadows. Thank you. The question has been raised as to why we are here today dealing with this issue. All of us have taken the oath of office, and it basically says, I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, and I will bear true faith and allegiance to the same. We're really here about the Constitution of the United States. We know that Article 1, Section 9, Clause 9 is the Foreign Emoluments Clause, which is very much the question before this committee at this moment. And Article 2, Section 1, Clause 7 of the Presidential Emoluments Clause is also before the committee at this moment. I think we would all agree that that is the issue at hand, and the reason we're here is to carry out our solemn oath of office. And both of you before us also took the same oath of office. So let us proceed then with some questions and an understanding of why we are here. Mr. Matthews, you stated just a moment ago that the tenant is in full compliance with the lease. My question goes to Ms. Ochoa. On page 23, paragraph 5, lines 6 through 9 of your report, you say, according to it, my question to you is, can the GSA state definitively that the Trump Organization, LLC, is not in breach of the old post office lease terms without an evaluation of these constitutional questions? In other words, can you tell us definitively that they are not in breach until such time as the constitutional emoluments clause issues are dealt with? We put that in the positive. Are they in breach of their lease because of the emoluments clause and the lease language itself?
It's hard to have a full discussion of that issue without being able to discuss GSA's legal opinions. Certain portions of our report have been redacted based on claims of privilege. What I can say and what we said in the report is that without employing the doctrine of constitutional avoidance in their interpretation of Section 3719, they foreclosed a way of taking the emoluments issues off the table.
So they pushed aside the fundamental constitutional issue of emoluments and simply said that's not relevant. Is that correct?
They said they were not going to decide the issues. I don't think they said they were not relevant. They recognized it was an issue. It was an issue relevant to the lease, but they decided that they were not going to attempt to resolve the issue.
On page 8 of your report, you say that he, I suspect you mean the president here, still retains his financial interest in the property. Is that your view? Is that correct, that he does maintain a financial interest in the property?
I believe that's a fact.
Okay. Mr. Matthews, does the president maintain a financial interest in the property?
I believe that's correct, yes.
So your answer is yes, he does maintain a financial interest in the property.
I'm not familiar with all the details of the financial structures of the company, but I believe that's correct.
You believe that's correct?
I do, yes.
Thank you. Now, are you aware of any payments made to the hotel from foreign governments? For both of you, Mr. Matthews first.
So GSA, we're not involved in the daily management of the hotel. That's why we did an outlease.
So you are unaware of any payments from any foreign governments?
I've certainly seen press reports.
But you have not asked for or received specific information on that issue, even though it would be a question of the emoluments and the lease itself?
Well, with respect to the question of the emoluments, that question's pending before the courts.
We understand that, but my question to you is, have you attempted to collect any information on payments from foreign governments, even though the lease itself raises that issue?
We don't receive that
So the answer is no,
level
you
of
have not.
information in the financial
Ms. Ochoa,
documents.
do you have any information
Jill.
about payments from foreign governments?
Gentleman's time has expired.
Would you like me to answer the question?
You can answer the question.
We don't have direct access to the books and records of the hotel.
Thank you. Thank you, and I yield back.
Thank you. Just for clarification, Mr. Lamata will be glad to hear this. I think y'all can tell him. He was talking about a request for funding for a new building in Laguna Niguel. GSA sent us that perspective 3 weeks ago, and minority and majority staff are already meeting with GSA on that subject. So we'd like to share that information with them. Now, Mr. Weber is recognized.
Thank you, ma'am. It's appalling to me, too, that we're kind of here because District 14 in Texas is a Gulf Coast district, and we've had Hurricane Harvey 2 years ago we're still trying to recover from, and now Tropical Storm Imelda. That's the things we should be focused on, in my opinion, but we're here. Mr. Matthews, you were sworn in August 2017. You stated that the lease was signed August the 5th, 2013.
Correct.
Do you know when those negotiations for that lease began?
I believe they began in 2012.
2012, okay. So it was well before Donald Trump's announcement, June 16th of 2015, that he was going to run for president.
Yes, absolutely.
Okay. Are you aware of the lawsuits that have been filed against Trump over this hotel, the 3 lawsuits we call the Crew suits, for example?
Yes, that's correct.
And how about you, Ms. Ochoa? Are you aware of those?
I am, yes.
Are you aware that at least 2 members of this committee are associated with those lawsuits?
Am I personally aware?
Yes, ma'am.
I haven't reviewed the
How about you, Mr. Matthews? Did you know that?
Yes.
Okay, you did know that. Once the GSA contracting office made the decision about the emoluments clause and decided to move on, was that sufficient for the 2 of you? Mr. Matthews, we'll go with you first.
Well, I would say that decision was made, by the Inspector General's own report and testimony in December of 2016.
Right.
And
So
subsequent.
was it sufficient for you? Did you say, okay, we'll move on, we'll do the American people's work?
Well, I didn't arrive until 2017, so that ship had pretty much.
But when you got there, it was sufficient. Was it sufficient for you, Ms. Ochoa?
No, for the reasons stated in the report.
I got you, okay. Well, we would love for this committee to be able to do the same thing, move on, do the American people's work as well. I'm going to yield back to the ranking member the rest of my time.
I thank the gentleman from Texas, Ms. Ochoa. I'm going to come back and follow up on my good friend from California, Mr. Garamendi's question, because he was talking about a memo that I guess is privileged from December of 2016. Is that correct?
No, there's not a memo from December 2016. It's the
All right,
memo.
so the privileged memo that you were talking about, what privileged memo are you talking about there?
I'm talking about the legal opinions that GSA's lawyers wrote in connection with advising the contracting officer about his interpretation.
And when did those legal opinions get written? When were they written?
Those were in March of 2017.
And they were written by whom?
They were written by GSA lawyers who were part of the team advising the contract.
And those team, and it was at that particular point, had they been, that legal team, were they part of the Trump administration? Were they political appointees, I guess is what I'm getting at? Or were they people who had actually worked at GSA during the procurement process?
It was the same team of lawyers spanning both administrations. These were career attorneys, yes.
I'm sorry, I didn't hear you. Could you repeat that?
The same team of lawyers looked at the issues spanning both administrations. They began looking.
Yeah, but I think according to your testimony, it says the Office of General Counsel, OGC, made the decision not to address the emoluments issue by mid-December 2016. Do you stand by that?
I do, yes.
Okay. Was President Trump in charge of that decision at that particular point? Had he been inaugurated at that point?
No.
All right, so any nefarious purpose of the emoluments issue being addressed, how would that have anything to do with the current president? If the decision was made in December of 2016 during the last months of the Obama administration?
Our report didn't ascribe any nefarious.
No, but I guess what I'm saying is there seems to be an implication that this administration was the one that actually said that there's not an emoluments issue, and I guess you and I both know what the real story is, and those decisions were made under the previous administration. Isn't that correct? According to your testimony.
Congressman Meadows, I would love to be able to talk with you about the legal opinions. I cannot. Because
well, did they happen in December? Do you stand by your testimony that they happened in the mid part of December of 2016?
They made the decision to ignore the issue in December of 2016.
All right, and do you think that President-elect Trump was putting pressure on them to make that decision at that point?
I have made no such.
Do you have any evidence that would suggest that?
If we had found any such evidence, we would have reported it.
I thought so. I yield back.
Mr. Johnson is now recognized.
Thank you, Mr. Matthews. Prior to becoming Public Buildings Commissioner at GSA, you worked for several Republican congressmen out of California, and then you went to work for the House Rules Committee on the Republican side, and thereafter you came to the Transportation and Infrastructure Committee, where you ended up as staff director of the Transportation and Infrastructure Committee's Subcommittee on Public Buildings. And after that, you then went to the administration as Commissioner of Public Buildings. Is that correct?
Yes, that's correct.
And you are what we call a political appointee, isn't that correct?
Yes, I am.
And you've had absolutely no experience in running a large organization, isn't that correct?
No, that's not correct.
What large organization have you managed?
I was the Assistant Deputy Commissioner of the Texas Department of Health. And
Assistant Deputy
Commissioner
Director
of the Texas Department of Health. And,
okay.
And under our responsibility was several
okay, well,
thousand
I don't want
people
your
and a
I don't
couple
want your
billion
range
dollars.
of responsibility, but I will say that welcome back to the subcommittee that you now are a Public Buildings Commissioner answering to your prior subcommittee as a political appointee. Now, let me ask you this question, sir. On March 20th, 2017, the Trump Post Office LLC requested an estoppel certificate stating that the company was in full compliance with Section 3719 of its lease agreement, and GSA, your organization, the Public Buildings Department, issued the letter. Isn't that correct?
Yes, I worked for this committee at the time, but yes.
Well,
that's correct.
yeah, but so my point is that in issuing that estoppel letter, it was done 3 days after it was requested. The estoppel letter was issued 3 days after the Trump team requested it, correct?
I don't know how many days.
You don't know how many
we can
days?
find
Well,
out
you
for
wouldn't disagree then. It was 3 days. And what kind of assessment would take place prior to granting us an estoppel certificate by your department?
Well,
what would normally happen?
So there is
and how long does it normally take? That's the question I want to ask.
So there's a structure in place for making contract administration.
Does it take longer than 3 days?
Again, I don't know if it took 3 days or how long that was under consideration.
Let me ask you this question. How many employees in your public buildings department?
It's a little under 6,000.
6,000 employees, and how many public buildings?
Well, when you include our lease portfolio, we have well over 10,000 facilities.
And so you've not had a chance with all that responsibility to review what actually happened on this Trump post office lease. Is that correct? Even though you were the staff attorney for this subcommittee.
I'm not an attorney, but I was the staff director of the subcommittee.
In fact, you have a degree in government and philosophy.
From Georgetown University, that's right.
And so now you're managing this big organization here. Have you received any phone calls from Donald Trump Jr., Donald Trump, Eric Trump, or anybody concerned with the Trump organization during your tenure as Public Buildings Commissioner?
No.
You have not?
No.
Are you certain about that?
Yes, I am.
How did, or why was it that GSA did not embark upon a study to determine whether the post office lease to the Trump organization was compliant insofar as the emoluments clause of the Constitution is concerned?
Well, again, that decision was made in December of 2016 by the previous administration.
And you could have had it reviewed yourself, could you not? To determine constitutionality, isn't that your responsibility?
Well,
as Public Buildings Commissioner?
I would say the conditions have changed since 2016. There have been a number of lawsuits filed, and this very question which you're asking is pending before the courts. And in that forum, the Department of Justice, who speaks for the executive branch, in that forum has argued there is no violation of the Constitution. And so
But
it wouldn't be appropriate.
your department never undertook such a review. Is that your testimony today?
I'm sorry, is that for me or?
No, that's for you. You should know you're the director, you're the commissioner.
Gentleman's time has expired.
no,
Can
they
you
have
answer
not.
that, yes or no?
No, and it wouldn't be appropriate
Okay,
for
thank
us
you.
to do that.
We'll now recognize Mr. Perry.
Thank you, Madam Chair. Inspector General Ochoa, according to the report, the OIG began the evaluation of GSA's management and administration of GSA's ground lease of the old post office building in July of 2017 in response to numerous complaints from members of Congress and the public at large about the management of the lease. The complaints generally raised two issues regarding the lease. One, does the Foreign Emoluments Clause or the Presidential Emoluments Clause of the U.S. Constitution bar President Trump business interest in the Trump Old Post Office LLC tenant? And number two, does the president's business interest in tenant violate Section 37.19 of the lease? The next paragraph of the report explains that the OIG did not seek to determine the accuracy of either complaint, rather sought to determine whether there were any improprieties in GSA's decision-making process regarding these issues. My question at this time is, why was the evaluation aimed at the decision-making process regarding the complaints rather than addressing the complaints themselves? In other words, did something preclude you or GSA from evaluating the emoluments question itself?
In the first instance, the responsibility for evaluating those issues was with GSA management. They had made their decision by the time we opened our review, and that's why we scoped our review to look at whether there was anything improper in the way they went about making those decisions.
And the second case?
In both cases.
You said in the first case, it was management.
In the first instance of addressing those issues, that was GSA management's responsibility. Our oversight extended to how GSA fulfilled its responsibilities.
Why didn't you just address the questions themselves? Do you know why? I mean, you're the OIG, so you would know why they made that decision to look at the process as opposed to the questions themselves.
Yes, yes, I do know why. It was a matter of exercising judgment as to the scope of the review. It wasn't necessary for us to resolve the merits of the issues in order to determine whether GSA was correct in recognizing there was a constitutional issue and whether their reasons for avoiding it were valid.
So it wasn't necessary to answer the question of the complaints by members of Congress or that's what you're saying right now. You answered the administration of it, but not the questions themselves, and you made that judgment.
I made the judgment that the review was appropriately scoped to address the concerns of the complaints.
And the concerns of the complaints were regarding the emoluments clauses themselves, not the process by which you would evaluate them, and you decided not to do that.
It's one and the same. It's how did GSA come to its conclusion?
Well, no, because we don't get the answer, right? I mean, the answer according is that it's settled constitutional law, but obviously it's not settled constitutional law. Let me ask you this: when did you start your role as the IG for the agency?
In July of 2015.
2015.
July, yeah.
Yeah. So you've been there for a little while. You're not a puppet of the administration. You're doing the job that you think that you're supposed to do, regardless of who is the president or not and what interest they may have. Mr. Matthews, regarding other similar leases that might be close to the old post office, do you receive monthly statements from other leases in accordance to what's been asked of you in this hearing?
Yes,
So, and you receive them from the Trump Hotel as well?
we do.
And do you receive a breakdown of how much the profit or loss is based on the lease on a weekly, monthly, whatever basis?
So we receive a monthly financial statement and an annual audited financial statement.
And it's the same for all of them,
I believe it is for all of them, yes. I can confirm that for you, but I believe that's correct.
generally speaking, right? There
Yes.
might be an outlier, but it's the same for all of them, and it's the same for the Trump Hotel / the old post office. No difference, right?
That's correct.
So what you're being asked today, even though, according to my good friend from California, the reason for this, the focus of this hearing is on the emoluments clause, but we keep on being concerned about how much money we're getting, you're reporting the same as you do for the Trump Hotel as everyone else. And what you're being asked here today is to provide something wholly separate, unique, and different than every other lease that you manage.
That's correct.
And how many leases do you manage?
Over 8,000.
Thank you, Mr. Chair. Madam Chair, I yield my time.
We would want to clarify that there are only 6 of these out leases. So when you talk about the thousands of leases you have, those would not be the same type as the type you have with the Trump Hotel. Is that correct?
Out
Yes,
leases
thank you.
are-
All right, we'll now recognize Mr. Brown.
Thank you, Madam Chair. I want to thank my colleagues on the committee for their attention and diligence on this issue. And I understand, I realize that a number of the questions, lines of inquiry that I had have already been covered. So let me just start by saying I'm really troubled. I'm like disturbingly frustrated to know that a federal government agency, the GSA, its officers, its attorneys, its supervisors, do not fulfill their responsibility to consider, uphold, and enforce all of the laws of this country, whether it's rules, executive orders, statutes, and yes, the Constitution. And to learn from the IG's report that responsibility was shirked, it's disturbing, to say the least. I don't think that any public servant, members of Congress, the president are above the law, but I don't think that sentiment is shared at 1600 Pennsylvania Avenue. The bottom line is that if the president had fully divested from his company, this hearing would not be necessary. Instead, we have to discern whether the president is putting his business and personal interests above our nation's. We have to question why foreign leaders, lobbyists, and even the Attorney General is choosing to spend tens of thousands of dollars at the Trump International Hotel, and whether the president is trying to enrich himself in direct violation of the Constitution. Commissioner Matthews, I want to direct this question to you. According to the Office of Inspector General's January 2019 report, and contrary to both your written and oral testimony here today, GSA failed to appropriately consider the emoluments clauses, both, to the U.S. Constitution in regard to the old post office lease, as well as Article or Section 37 2019 of the lease. Mr. Commissioner, has anyone in the GSA Office of General Counsel provided you or any of your colleagues any guidance on the emoluments issue since the January 2019 report was issued?
The answer is no, but this emoluments question is pending before the courts, and that's...
Yeah, I understand that, but so in anticipation, you have not made any inquiry of your general counsel on this issue?
It wouldn't be appropriate for GSA to opine on this.
I was just asking yes or no. I mean, I'm just asking if you or any of your colleagues have made inquiry of your general counsel on the emoluments issue since the IG's report in January of this year. Just yes or no. It sounds like the answer is no, you have not. Is that correct?
That's correct.
The committee has been requesting records relating to the Trump Hotel financial statements to the GSA. And I know a number of members have asked about it. Has the GSA Office of General Counsel provided you with guidance on how to track expenditures at the Trump International Hotel or any other similarly situated hotel relating to rental or lease fees derived from foreign, federal, or state governments?
Well, under the lease, the tenant's obligated to provide monthly and annual audited financial statements.
And do they report revenues by revenue source, whether it's a foreign, federal, or state government? Yes or no?
The financial documents, again, we are working with.
Well, I'm just asking you a question. I mean, it really is a yes or no. I mean, I appreciate your desire to provide a lengthy explanation, but is there a process where the revenues are reported by source, specifically federal, state, or foreign governments?
We don't receive that sort of breakdown.
So if the courts were to rule that there's a potential emoluments clause problem, are you saying that you don't have the systems in place to identify whether a foreign government paid a rent or lease or for services at the hotel?
I'm not going to speculate on what the courts may or may not do.
So you're just going to wait until the court acts until...
What the implications that may or may not be for GSA.
Have you asked your general counsel about guidance on this issue?
I'm not going to speculate on what the courts are going to do.
No, I'm just asking you, have you asked your general counsel about the issue of whether or not you should or shouldn't track the sources of revenues or fees that are paid at the Trump Hotel?
The tenant complies with the lease, and the lease has provisions.
So have you asked your general counsel?
I'm not going to discuss the...
Okay, so you're not going to answer that question, yes or no?
Counsel, no.
Let me just be clear. Are you going to answer yes or no the question I just previously asked?
Look, the answer, I'm trying to answer your question.
Okay, then let me restate the question. Let me be a little simpler in the question.
Financial statements.
Let me be a little simpler. I reclaim my time. I'm reclaiming my time.
The gentleman's time has expired.
Okay. Boy, 5 minutes flies.
Now I recognize Mr. Westerman.
Thank you, Madam Chair. Thank you to the witnesses for being here today. Madam Chair, I was excited to see that we were going to be talking about the billions of dollars of federal assets that are sitting out there unused, but unfortunately, that's not really what this discussion's about. You know, I thought we had, this horse had been ridden hard and put up wet, but apparently it died in the stable, and somebody wants to bring it out and beat on a dead horse a little bit more. But there are serious issues this committee should be addressing. Just in my hometown of Hot Springs, Arkansas, we've got a 200,000 square foot hospital. It was the original Army-Navy hospital used from the 1800s up through World War II. It's a historic building. It currently needs a tenant. We have a national park there where we've leased out historic bathhouses to private businesses. We need to be doing more of that to take care of these old historic buildings instead of having hearings to beat up on one of these buildings that actually is a success story, how we reuse federal assets. And it's just a rhetorical question, but when are we going to start focusing on the real issues? And I would like to yield the remainder of my time to Ranking Member Meadows.
I thank the gentleman from Arkansas. Ms. Ochoa, I'm going to come back to you. So when you were preparing your review of this lease and drafting the report, did you reach out to outside legal counsel?
No.
All right, so all your legal experts were from within the IG's office, is that correct?
The team that did the review was with inside.
In the drafting?
Yes. Yes.
So they're on your IG staff, is that correct? All right, so who on your staff is a constitutional expert?
Actually, the 3 senior members of the team have over 70 years of combined experience handling constitutional litigation at the Department of Justice.
All right, so with the Department of Justice, obviously you were very critical with the GSA. You were very critical of the GSA and not consulting, with GSA of not consulting DOJ, is that correct?
Yes, and not reaching out to try to find a solution to the issue that was presented.
All right, so when you were drafting the report, did you take into effect the DOJ's position on this issue?
We looked at GSA's decision-making at the time that the decision was made, and we looked at what was available to them in that context.
So did you take into account their position, their published position as it relates to this particular question?
The position that the department developed in litigation doesn't affect the conclusions in our report.
Well, but by the IG statute, you're bound to look at all of those legal experts, and you're saying that the 3 people that you relied on were from DOJ, but did you rely on any current DOJ opinion in drafting it?
Look, we were aware of the DOJ litigating position.
So you just disagreed with it?
No, we didn't weigh in on the merits of the question that the DOJ litigating position is addressing. That's the merits of whether there is a violation of the constitutional emoluments clauses here. All we engaged in was really an issue spotting exercise, because before we were about to criticize career attorneys for failing to address an issue, we wanted to make darn sure they were right when they realized that it was a potential constitutional issue. That's what our report was about.
And so you use the key word there, potential, is that correct? So you're not making a definitive statement. You're not suggesting that the Supreme Court is going to come down on your side or GSA's side. You're not making an opinion there. You're just saying it could be a potential issue.
That's right. We're not trying to weigh in one way or the other. We don't know how the lawsuits will.
So when you did your report, did you look and analyze the potential legal and financial exposure to the taxpayer that the contracting officer may have had in making this decision? Was that part of your analysis?
Excuse me, can you repeat that?
Well, the contracting officer obviously made a decision based on unsettled constitutional law. Did you look at the potential financial implications that might arise from that particular decision?
We looked at the reasons that the contracting officer gave us and the lawyers gave us, and the financial situation didn't come into play at all.
All right.
What they told us.
So can you, I see my time's expired.
We'll now recognize Ms. Fletcher. Excuse me.
Thank you, Chairwoman Titus, and thanks to you and Ranking Member Meadows for holding this hearing today, and to the witnesses for taking time to testify. I want to clarify a few of the things that we've just heard and make clear that in response to one of the questions about the volume of leases that are similar to the one that we're talking about, that there are only 6 out leases of the type with the Trump Hotel in Washington, D.C. That's correct?
We have far more than 6 out leases.
Okay, but of the, actually, in a July 18 GAO report prior to the 2019 report that we've been discussing, it analyzed the GSA's outleasing program and reviewed, quote, the extent to which GSA has included lease provisions in its outlease agreements related to the participation of elected officials in these outleases. And according to the GAO report, there are only 6 federal buildings with at least 20% outleased by GSA. Do you disagree with that report?
I'd have to have it in front of me, but we outlease space in federal buildings all across the country. In our building, for example, we have 3 outleases that I can think of. One is for a coffee shop, one's for a Mexican restaurant, and another is for a sandwich shop.
Does that total more than 20% of the building?
No, those do not.
Okay, so of the buildings with at least 20% outleased by GSA, the report concludes that there are only 6 of these buildings, and all but one of those leases contains a provision restricting participation by elected officials, and that is the Silvio O. Conti Federal Building in Pittsfield, Massachusetts. Are you familiar with that?
Not with that particular building, no.
Inspector General Ochoa, did your team raise this issue with the GSA? In connection with the recommendation, your team raised this issue
We've
with the
had
GSA?
some discussion about the fact that the language of 3719 is still in 2 of those outleases, and that it has not been modified to resolve the ambiguity. And we've also pointed out that with respect to one of those outleases, just a year ago, GSA told GAO that using that language was a best practice for GSA, and they intended to modify a lease that didn't contain it.
Okay, and so their response was that they intended to modify it. Commissioner Matthews, has the GSA indeed modified that provision or added the language to the Conti building lease that would restrict participation by elected officials?
So what we agreed to do was in future outleases to remove that interested parties provision, replace it with language referencing the underlying statute which those provisions were based upon.
So the answer to my question is no, it has not been revised for the Conti building lease. Is that correct?
I don't know, but I'd be happy to get that answer for you. But what we
If you
said
could
we
please
would do-
provide that answer for the record,
Yes,
that would be helpful. And with respect to the future leases, as a practicing lawyer before I got here, litigating leases and contracts and disputes, I'm curious as to how you determined that a reference to the underlying statute was superior to an express provision in the contract, an explicit provision in the lease requiring compliance. Can you explain the rationale for that decision?
Well, the rationale was to remove the ambiguity in the contract provision, and referencing the statute explicitly would eliminate that ambiguity.
Do you think that referencing the statute explicitly in addition to the explicit contractual provision is an appropriate correction to the ambiguity?
Well, I think the concern is that the interested parties provision itself in the contract has some ambiguity to it. And so our proposed corrective action plan would eliminate the use of that provision in future contracts and instead replace it with a reference to the underlying statute.
With simply a reference to the statute as amended?
Yes, correct.
From time to time? I don't know. I have one other quick question. I want to follow up on a question that my colleague, Ms. Davids, asked you about the auditing. It was my understanding from your testimony that the lessee selects the auditor for the audited financial statements that you receive. Is that correct?
Yes.
Okay. And do you have a list of approved auditors?
If we do, I'll be happy to get it for you.
And do you require any specific standards of the auditors, for example, GAAP accounting, even if it's a non-public company?
They have to comply with those standards, is my understanding.
And do you have any employees who review the audited financial statements for these 6 specific outlease buildings?
I'm sorry, I couldn't hear you.
I'm sorry, the lady's
I believe
time
my
is up.
time has expired. Thank you very much, Madam Chairwoman. I yield back.
Thank you. Mr. Meadows?
Thank you, Madam Chair. So, Mr. Matthews, let me come back on this lease to make sure we are crystal clear. It is a lease that allows for a base amount of money to be paid to the American taxpayer of approximately $250,000 a month or $3 million a year. Is that correct?
That's correct.
And then there are thresholds that are above that would basically be based off of gross revenue. Is that correct?
Correct.
So the operational expense, wherever it is, we're just looking at gross revenues and a percentage of that would adjust the lease payment. Is that correct?
That's correct.
Is that not the most transparent way to do a lease where you have a plus up from a base amount, where you don't get into how much it cost that you paid your waiters or how much you paid staff or anything else? If you do a gross revenue, is that not the most fair way to the American taxpayer to find an adjusted base lease? Is that correct?
Yes, it's correct.
All right, Ms. Ochoa, would you agree with that?
I haven't considered those issues.
You haven't considered those issues?
No.
All right, so well, let me ask you this, Ms. Ochoa. Do you believe the American taxpayer is receiving more money under the Trump hotel lease or less money than they did prior to it being leased to the Trump organization?
I accept what I'm hearing about the loss prior to the hotel beginning operation and the $3 million a year since.
All right. And the delegate from D.C. has been very active on trying, would you agree with this, Mr. Matthews? The delegate has been very active on making sure that we use underutilized buildings in the District of Columbia and make them producing assets. Is that something that the delegate and I have been pestering you about for some time?
Yes, and I'd say it's been a bipartisan priority of this committee for well over 20 years.
And would you say, other than the fact that the President of the United States is associated with the Trump Hotel, would you say that that is a good model for all of the underutilized properties in terms of taking it from what it once was to what it currently is?
Absolutely. It's
All
a
right.
tremendous financial project.
So, Ms. Ochoa, let me come back to you because you make a number of assertions throughout your report that are without citations in your report.
I would have to disagree with that.
Okay, well, you can disagree, so I'm going to give you a chance to clarify, because it doesn't give us any way to verify the accuracy or context of that. And so, in fact, just in the last few weeks, I believe that Chairman Johnson, the senator from Wisconsin, provided your office with some details highlighting specifically where in your report supporting documentation would be useful in his oversight. Do you plan to respond to that?
Of course, we've been working with their committees for several months trying to respond to your requests.
All right, so Chairman Johnson's response, you're planning to respond to that. Will you give that to this committee as well?
We can do that. Are you making a request for that same?
I am making a request for that. Now, when can we expect those responses? I don't want to speak for the chairwoman, but I'm assuming that she would want clarification for any report that the IG does.
Look, all along we have been providing equivalent information to the majority and minority
And that is
of the
true. The
committees who are
staff has
asking
been
these
working with them,
questions.
So when can we expect a clarification of that report with what Chairman Johnson is requesting and what I believe the chairwoman is alluding to?
I haven't had a chance to look at what's being requested. I understand it's a request for more documents. We'll look at it and we'll do what we can. We've been prioritizing documents for GSA for months now. Most of the documents that we relied on in the report that aren't public in nature that we already turned over are the agency's legal memoranda, the email exchanges among the attorneys working on the matter and with the contracting officer and between the contracting officer and the attorneys and the Trump organization. We have produced and reproduced those and winnowed them down for GSA to look at, to provide to these committees.
So are you aware, Ms. Ochoa, of any reason other than perhaps a court decision why that the Trump organization would be in default of the current lease? Are you aware of anything other than perhaps this emoluments question that's out there?
There's Section 3719. The two of them are not independent of each other. And
So,
beyond that,
so those together. And so do you believe that they're in breach?
I'm going to stand on my report, Ranking Member Meadows. We did not make that ultimate determination. I would love to discuss with you the agency's legal opinions, but I cannot.
Gentlemen's time is up. I just want to clarify, too, for the committee, the problem has not been getting information from the IG. The problem has been getting information from the GSA. Well, now I recognize Mr. Cohen.
Thank you, Madam Chair. Is it Ochoa? How do you pronounce your name? Commissioner, how do you pronounce your last name?
It is Ochoa. Thank you.
Ochoa, I had it right, thank you. You were talking about Section 37 and 37.19?
Correct.
And that seems to me to be pretty clearly obvious that the exemption that's put in here to say that public officials could engage in a lease is if they are for the general benefit of a corporation or other entity, that and the corporation or other entity is publicly held. And the idea being that if an individual owns some stock in Hilton or another hotel company or a REIT they weren't the significant owner, significant beneficiary, or involved major in management, that it'd be okay because it's like a de minimis involvement. And that's clear. But it said, as previously noted, the GSA has asserted privileges over the OGC's opinion on that section when they look to interpret it. Why would they have exert a privilege rather than just release their opinion? To me, as a lawyer, it's pretty clear that the other entities is connected to the public ownership, and it's an exemption for people who own stock that is a de minimis amount of influence, as distinguished from somebody who's a primary partner. Is that not accurate?
Look, I'd love to talk with you about the agency's legal opinions. I can't. I think our report does point out that there is an interpretation along the lines that you are.
You can't talk to me about it because it's privileged? Or they assert privilege?
Yes.
Which is hooey, in my opinion. Let me ask you this question. Let me ask Mr. Matthews this question. In 2017, on August the 2nd, the United States went to court at the request of GSA's acting commissioner of public buildings to condemn a leasehold interest in a property in Myrtle Beach, South Carolina. GSA had leased office space for the FBI in a building owned by Rice REI, Limited Liability Corporation, wholly owned by Congressman Tom Rice. Tom Rice is a friend. I like Tom a lot, and I'm not questioning him whatsoever. He entered into this lease way before he was elected to Congress. But GSA went to court, and in the complaint, the United States argued contracts between members of Congress and the federal government are prohibited, and the lease in question was voided upon Congressman Rice's election and assumption of office. And I have a copy of the complaint here, and I'd like to enter this into the record. That's without objection. Without objection, so when GSA contracted with Congressman Rice's LLC and disregarded his corporate shell and regarded Congressman Rice as the beneficiary of the lease with GSA. Is that not accurate?
Yes, that is accurate.
Well, when it comes to President Trump, why did you not try to go beyond the corporate shell and try to see if President Trump was affected?
Well, the compliance with the lease is determined by the contracting officer, and the contracting officer, in consultation with the Office of General Counsel, made the determination that the tenant was in full compliance with the lease. The situations are not comparable. There is a statutory
I understand all of that, but
yes.
Basically, you're looking for some reason to treat Mr. Rice different than President Trump, and there really isn't a reason, in my opinion. Inspector General Ochoa, does this inconsistency concern you, that they look at the president differently than they look at Congressman Rice?
We've been discussing that issue of dropping Section 3719 from the contracts in light of the fact that up until recently, GSA thought that was a best practice, and in light of the fact that during the course of the review, we were told that they specifically inserted the additional language about state and local officials and the president and vice president to prevent interference with contracts.
Is it not good policy to say that public elected officials can't benefit from a government lease? That's good public policy. Why should we be concerned about that? We're concerned about it because we've got a new person involved. Is President Trump's corporate shell the only shell that GSA has refused to look through in order to determine the beneficial interest in a lease with GSA? Mr. Matthews, is his corporate shell the only one?
Again, with respect to whether or not the tenant is in compliance with the lease.
I'm asking you, have you gone beyond is this the only corporate shell you've tried not to go into?
I wouldn't know the answer to that question.
Well, you should. Are you aware of any other leaseholds, leases that you have with Donald J. Trump may be the beneficiary?
I'd have to get back to you, not that I know of.
Is the Monaco Hotel lease the same basically as Trump's, that is a percentage of the gross or a minimum?
I'd have to review it specifically, but I believe it's an identical lease.
Have you audited the Monaco Hotel to see if they pay more?
I believe we receive the same types.
Do you know
of
if Monaco
financial
Hotel pays over the minimum and pays based on the gross proceeds? Can you answer my last question?
I'd be happy to get back to you with that information.
You'd be happy to get back with me. You need some work. I yield back
Thank
the
you.
balance
The
of my
gentleman's time has expired. Well, that seems to be a lot of questions for these two witnesses, so we'll now start a second round of questioning. We'll begin. All right, we'll begin with Mr. DeFazio.
Thanks, Madam Chair. I just want to get back to this issue about the base rent. As of now, adjusted by CPI, according to your testimony, the base rent is $267,653 a month. Is that correct?
I don't know the exact number offhand.
Well, that's in your testimony.
Okay.
Okay, good. So, and if the proceeds of the hotel on an annual basis exceed 12 times that amount, okay, which would be $3,211,836, the tenant is obligated to pay 3% of any overage, $1, $1,000, $1 million. Is that correct?
That's correct.
Okay. So, in the last released monthly that we have, from April 2017, the gross was $1,965,000. So if you multiply that times 12, that comes out to $23,580,000 a year. But you're telling me that somehow we're back to the point where the Trump Hotel is only grossing $267,653 a month and doesn't owe us a penny more. Because I've asked you, how much more are we getting? And you have stonewalled that, and you just keep going back to the $267,653. Let me try it one more time. On an annual basis, has the Trump Hotel revenues exceeded 12 times that amount, which is $3,211,836? Yes or no?
I think the confusion.
Yes or no? There's no confusion.
I'm afraid
we
there
are
is.
due additional funds if they exceed $3,211,836. I'm asking you a simple question. Have their revenues exceeded that in the last year? Because you have not given us a statement on that.
I'm afraid you're conflating the gross revenues with the rent.
The rent
Talking about
is
different-
obligated. Gross revenue that exceeds the rent is we're to get 3% of it. You understand that? You just agreed to that.
3% of the gross revenues.
Over and above the rent.
The way this is structured,
look, I think you're misinterpreting the contract, because our understanding of staff, and I asked you this question before, is that he pays the base rent. And if his revenues exceed the base rent, we are due 3% of the gross over that amount.
That's not correct.
That's
not the way it works.
Well, that's the way the staff has explained it to me. So you tell us how it works. So very quickly.
So the way it works is the rent is based upon the gross revenues. And the
rent was set in the original lease, and it was at $250,000, and it's now up to $267,000, correct? By CPI.
There is a floor.
Right.
So there's a minimum rent payment.
That's what we're asking.
Approximately $3 million.
Right.
But
you keep coming back to that. So you're saying we're not getting a penny over that because there's no revenue over and above that. That's what you're telling us. The Trump Hotel's losing money?
I'm afraid I'm not doing a good job explaining this. The gross revenues, the rent that we receive is based upon the gross revenues. We receive 3% of the gross revenues in rent. And there's a floor, a minimum of $3 million in rent.
Of $3,211,080 $836. But you're saying we're not getting a penny more than that they don't owe us anything else. The 3% provision hasn't been triggered.
We're getting the minimum rent amount. That's correct.
Okay, so you're saying then that this hotel is essentially a failure because in 1 month
No,
they had revenues of $2 million, and you're saying now their revenues are somewhere around $267,000 a month.
No, I'm not saying what the revenues are at all.
I know. Well, you certainly aren't because you won't provide us the documents. So we don't know what the revenues are or aren't. Will you provide us don't have to give us what was released here, which is nothing proprietary, but okay, will you give us the gross number for last year?
We are working with the committee to accommodate.
No, you're not working with the committee. I've been asking for this data for a very long time. And we're going to only have one recourse if you keep stonewalling us here. You are stonewalling us. You are not, you're telling us that all we're getting is the base rent and nothing else is due, but you won't substantiate that. You're accepting their audited statements. You won't show us those. And you have, and then we have the legal opinions, of course, which we can't see either. So we're kind of looking into a black hole here. I mean, there's the document we gave to Congress. You even black out who signs for the tenant. What the hell is that about?
The chairman's time has expired. Well, Mr. Meadows?
So let me see if I can add some clarification since I've worked on leases for a long time. You have a floor in a lease, and the lease amount is 3% of gross revenues with a floor. Is that correct?
That's correct.
All right, so in order to hit the floor amount, the gross revenues would have to be closer to $100 million in order to hit that floor amount. Is that correct?
That's correct.
All right, so what we're essentially saying is the way the lease is structured is that in order to get above that figure, you're actually having to have gross receipts above $100 million. So $200 million actually would have changed the amount that is paid to the federal treasury if the gross receipts are $200 million. Is that correct, Mr. Matthews?
Yes, that's correct.
So I've tried to explain that what happened is this is a good deal for the American taxpayer. We can take the other emoluments questions separately, but indeed, when you look at a hotel and we're getting a base amount of lease, the way this is structured is to protect the American taxpayer, not to penalize them. Is that correct, Mr. Matthews?
That's absolutely correct.
So I don't know what is so complicated about this, because when we look at the lease, it is very clear, if you're looking at a lease, how you would apply this. Have you actually worked on leases before, Mr. Matthews, when you were a staffer?
We reviewed them sometimes.
You reviewed them. Yes. Did you work on legislation that applied to public buildings when you were a staffer here?
Yes, for a very long time.
Did Chairman Micah have a real issue with public buildings where, that's a softball question, did he have an issue with public buildings and the accountability and what we need to be doing with public buildings?
He did. He made it a very high priority to protect the taxpayer through federal real estate.
All right, and will you commit to this committee that you're willing to go and look at other ways to verify that the Trump organization is paying the proper amount to the American people? Are you willing to look? So if I give you other ways to verify this number that is beyond just an audited return, are you willing to do that?
We'd absolutely take it into consideration. We'd certainly look at that, absolutely.
All right, so is there any malicious part on behalf of you or the GSA to try to cheat the American taxpayer out of revenue on behalf of the President of the United States?
No, of course not.
You know, I'm at a loss because we continue to come back. We've taken a non-performing asset, we've made it a performing asset. We've taken a $6 million liability and we've turned it into a surplus of $3 million. We've done that all without spending American taxpayers' dollars. We've allowed the President of the United States, when in his personal capacity, to invest in Washington, D.C. It was applauded by Democrats. It was certainly championed by all of us as a good thing for Washington, D.C. And then voila, all of a sudden, it is a bad thing because the President of the United States happened to win an election in 2016. You know, we're looking for an enemy here. There are important things for us to look at, but there is no doubt in my mind that this particular deal was a good deal for the American taxpayer. Would you agree with that, Mr. Matthews?
It's been a fabulous economic performer for the taxpayer.
So, Ms. Ochoa, I'm going to come back to you. Here's what I need. And you know that you've come before my other committee a number of times. This is not the first time that we go back. I love my IGs, and here's what I'm asking you to do. There are internal documents that you keep talking about with GSA. There are also internal documents that you have from an IG standpoint where it comes to the constitutional analysis that you have actually put forth in this report. Are you aware of any other time where you're actually have been asked to come in and make substantial constitutional analysis as it relates to the IG's work?
Actually, first I have to say that there are no internal documents that we have not
Emails
produced.
back and forth between your counsel as they were going back and forth, whether this applied or not, you don't have those?
What we relied upon for the analysis of whether there was a constitutional issue is all public source material, and we have provided that to your staff.
And so what the three people that you have, that internal deliberation, do we understand how they came to that decision?
Absolutely, it's laid out in the
No. In terms of their internal back and forth, can you get that to us? Do you have a problem with us having that?
With having
The internal
material,
deliberations of how you arrived at your constitutional analysis.
that's laid out in the report.
I think the gentleman's time has expired.
Thank you. There are two issues here, one of which is the financial situation with regard to the hotel, and that can be discussed back and forth. The issue that I want to focus on is the emoluments issue. And in the emoluments issue, both of you opined a while ago that the president continues to have a financial interest in the hotel. That was your earlier testimony. Without going back at that, the question then of emoluments becomes pertinent. The Constitution is very, very clear that the president cannot receive an emolument from a foreign power, prince or state, or from the United States beyond his salary, or from a state. That's very clear language. There is no debate about that. The question then with regard to the hotel situation is, does the president receive money from a foreign government? In that earlier question, neither of you had that specific information. And the question for Mr. Matthews is, why do you not have that information? Have you been asked that question?
Again, so we receive financial information based on the terms and conditions of the contract, and we receive the information we're required under the terms and conditions of the contract.
You're going to blow through my time here. Have you requested information about money from foreign governments and from state governments?
So the question of whether or not there is an emoluments violation is pending before the courts. It's not GSA's.
That's not my question. My question is, have you asked for that information? I think the answer is no, you have not. Is that correct?
No, that's correct.
Okay, so you've not. And Ms. Ochoa, have you requested that information?
We don't have direct access to the hotel's books and records.
So
we have access to GSA's material.
Have you requested that information?
We've not requested it from GSA at this point.
Madam Chair, I would ask that the committee request that specific information. Okay. Now, I believe that we have a slide. It's called Tracking Profits from Foreign Governments to the Trump Hotel. This is a slide that actually was given to the committee, and it came from the Trump Organization. And presumably, the Trump Organization is gives back to the Treasury whatever profits there may be. We've not determined that there are or are not profits, but my question really goes to how in the world we're going to determine the accuracy of any profit contributed to the Treasury when we have absolutely no information about any foreign government or any state government paying anything at the hotel. So is this useful or is this just a sham? Open question. Mr. Matthews, have you ever attempted to track any profit that's been returned to the Treasury?
That's not our role at GSA.
So the answer is no, you have not. And Ms. Ochoa?
My question remains with any obstacles to our access, the OIG's access to that information.
So once again, the rationale that the Trump administration used to get past the emoluments issue was that they would deliver to the Treasury any profit that was received. And yet we have absolutely no way to determine if there was any participation at the hotel by a foreign government or state government. We do have press reports, and we do have the testimony of the former governor of Maine that apparently the state of Maine spent $22,000 at the hotel. Now, the underlying question here goes back to the initial lease and the question of the estoppel. We have been denied the legal questions that were asked of the council. But we do know that there was a legal analysis done by the council. Is that correct?
That is correct.
We also know that Terry, the contracting officer, knew that the Office of the General Counsel recognized a violation of the Foreign Emoluments Clause might be relevant to a breach, and that this important issue remained open. This is your testimony, Ms. Ochoa. Do you stand by that?
Yes, that's what we found
So
in the report.
apparently the Office of the General Counsel raised a question about the emoluments, and that remains open today. And I would just simply say this is our task. Thank you.
Thank you. You know, we could talk about how much should be calculated under the lease, whether or not the lease was in violation of the emoluments clause and other such issues that may escape the scrutiny of the American people. But one thing the American people do understand is that the American people don't get a good deal when the President of the United States is the tenant and also the landlord. That's pretty much like the fox being in charge of security at the hen house. Everybody knows that that's a setup that is doomed to benefit the lessee, who is the same person at the same time. How could that work out to the benefit of the American people? And that is something that this subcommittee is well poised to address. Don't you agree with that, Mr. Matthews, since you formerly worked on this subcommittee? Isn't it our legitimate interest to oversee the operations of the General Services Administration, particularly in a situation where the fox is over the hen house?
The committee and subcommittee absolutely have oversight jurisdiction over GSA, yes.
So all of the things that my friends on the other side of the aisle have been saying all morning to somehow besmirch this hearing or to take away from its legitimacy, you don't agree with, do you?
I'm not going to opine on the minorities.
Well, I understand your loyalty, and but you also have a loyalty to the Constitution, do you not?
Yes, I do.
And thank you. With that, I'm going to yield the balance of my time to gentleman from Tennessee.
Thank you, Mr. Johnson. Let me go back to Mr. Matthews. Would you give us the agreement, the lease agreement with the Monaco Hotel and GSA, and let us know when you give it to us if they have paid more than the base rent and paid their rent based on the percentage of gross proceeds provision?
I'd be happy to take that request back, and we'll respond to your request.
All right, that's good that you'll do that, but you don't know for a fact if they have paid more than their minimum rent.
I don't know, and again, if there are provisions in the lease that restrict the financial information, we'll certainly have to work through that as well.
Well, it'd be interesting to know if it was similar or different. The percentage of the Trump family has decided at some point on their own that to not violate the emoluments clause, they would pay the hotel's profits that Mr. Trump would otherwise get to the United States Treasury at the end of the year to avoid violating the Constitution's emoluments clause. Are you familiar with that arrangement and decision?
Just by press reports.
Okay. Well, don't you think, Ms. Ochoa, that if the president has decided to donate his profits so he not to violate the emoluments clause, that's basically an admission that the emoluments clause is effective, as you have said, and that it should have been considered in determining the lease?
I'm not going to provide an opinion on those types of statements. We did find in the report that there is an issue, a constitutional issue with respect to the lease.
Thank you. And apparently the Trump family agrees. Now let me ask you this, Mr. Matthews. They give a percentage to the Treasury. Do you know what amount of money they give to the Treasury?
Are you referring to the lease contract or this other arrangement?
The other arrangement where the Trump family Donald Trump donates his profits.
I'm not familiar with that.
Well, I would submit to you, you ought to be familiar with it. If the President of the United States, who's your boss, decides he's violating the Constitution if he doesn't give this money to the Treasury, and you don't know if he's actually giving the percentage of profits that he gets from foreign governments, which you could know by auditing his books, and you don't know, you are being derelict in your responsibility. The President has said this is a constitutional issue, and he's going to give his profits to the United States Treasury, and yet you don't know what he's deciding to give and whether it's enough or not. This is within your purview, and Mr. Trump has basically said he's violating the Constitution, but so as not to seen as violating, he's going to donate a certain percentage. But there's not going to be anybody looking over his shoulder to see that he donates the right amount of money to not violate the Constitution? I guess that's an answer. You don't care. You want to answer?
What I would say is the question of an emoluments violation, that is pending several litigations before the courts right now. And in that forum, the Department of Justice has argued before the courts there is no constitutional violation right now. So,
but Mr. Trump has admitted it. Mr. Trump doesn't give away money for no reason at all. He doesn't even pay taxes. I yield back.
Madam Chairman, I have just a few unanimous consent requests. One would be, for the record, the Seth Tillman business transaction and President Trump's emoluments problem document. I ask unanimous consent that that be included. And then the amicus brief that was filed on the same subject without going into a long dissertation, I ask unanimous consent that that be included as well. I thank the gentlewoman, and I yield back.
We'll thank our witnesses and appreciate them staying with us so long, and they'll be dismissed, and we'll welcome our second panel. We'll take about a 5-minute break. I'm sorry, it's not a break, it's a recess, a 5-minute recess. I want to welcome our second panel of witnesses, Mr. Michael Foster, who's a legislative attorney for CRS's American Law Division, Ms. Liz Hempelwitz, who's Director of Public Policy for the Project on Government Oversight, known as POGO, Mr. Walter Schaub, Senior Advisor for Citizens for Responsibility and Ethics in Government Crew, and the former Director of the U.S. Office on Government Ethics, and Mr. Hans von Spakowski, who's the Senior Legal Fellow for the Edwin Meese Center for Legal and Judicial Studies at the Heritage Foundation. Thank you very much for being here. We're looking forward to your testimony. Without objection, our witnesses' full statements will be included in the record. And as with the previous panel, since your written testimony is included, we would ask you to please limit your comments to 5 minutes. We'll now proceed with the witnesses, and starting with Mr. Foster.
Chair Titus, Ranking Member Meadows, and members of the subcommittee. My name is Michael Foster. I'm a legislative attorney in the American Law Division of the Congressional Research Service. Thank you for inviting me to testify today on behalf of CRS to provide background information on the emoluments clauses of the U.S. Constitution and recent litigation concerning those provisions. In brief, under what I'll refer to as the foreign emoluments clauses of the Constitution, any person holding any office of profit or trust under the United States is prohibited from accepting of any present, emolument, office, or title of any kind whatever from a foreign government unless Congress consents. Additionally, a separate constitutional provision, the Domestic Emoluments Clause, provides that the President of the United States shall receive during his term a compensation for his services, but shall not receive within that period any other emolument from the United States or any of them. For most of their history, these clauses were little discussed and largely unexamined by the courts. However, recent litigation involving the President has resulted in multiple federal courts more fully addressing the scope and application of the clauses. Though these clauses and the litigation raise a host of legal issues, some of which I address in more detail in my written testimony, my testimony today will focus on the primary interpretive issue that has arisen in the recent litigation, namely the issue of what the term emolument, as used in the clauses, means. What constitutes an emolument within the meaning of the constitutional provisions is a key question that has divided legal scholars and has only recently been addressed by any federal courts. Several potential definitions of the term have been offered. The narrowest definition would limit an emolument to compensation for the personal performance of services as an officer or employee of a foreign or domestic government, but would not extend to ordinary business transactions between a covered official and such a government. By contrast, a broad definition that some have proposed would cover any profit, gain, advantage, or benefit, including even ordinary fair market value transactions between covered officers and a foreign or domestic government. The Department of Justice's Office of Legal Counsel, or OLC, has also sometimes appeared to employ a functional, fact-specific definition in rendering legal advice to the executive branch on whether the acceptance of particular payments or benefits by executive branch officials would implicate the clauses. Some OLC opinions, in assessing whether a particular benefit would constitute a prohibited emolument, have looked to the clause's goals of limiting influence on the President and federal officers, and have accordingly inquired into whether a benefit at issue is intended to or could influence the recipient as an officer under the totality of the circumstances. Debate over the definition of an emolument has largely centered on the text of the clauses, their history and purpose, and historical practice. For instance, proponents of the broad definition assert that the general anti-corruptive and anti-influence purposes of the clauses support reading it expansively and rely on contemporaneous dictionary definitions and practices of past presidents. In support of the office or employment limited definition, however, some scholars rely on competing contemporaneous dictionary definitions and usage by some founders, as well as the possible business practices of early presidents like George Washington. In 2018 and 2019, 2 federal district courts substantively addressed the scope of the emoluments clauses for the first time, with the courts concluding that the term emolument is defined as any profit, gain, or advantage of more than de minimis value. Regarding the clause's text, the courts found significant the use of modifiers like any other and any kind whatever, and rejected the proposition that the term's office-related use in another part of the Constitution should control under the clauses. With respect to the clause's history and purpose, the courts, while acknowledging that broader and narrower definitions of emolument both existed at the time of ratification, found the weight of the historical evidence and the clause's anti-corruption purpose to support the more expansive definition. Finally, the courts viewed executive branch precedent and practice as consistent with an expansive view of the meaning of the term emolument. These recent court decisions construing the emoluments clauses are not final, however. In fact, one of the decisions has since been reversed by the U.S. Court of Appeals for the Fourth Circuit on a separate issue regarding the standing of the plaintiffs to sue, and the other decision has been certified for an immediate appeal to the U.S. Court of Appeals for the District of Columbia Circuit. Thus, the import of these decisions as it relates to the meaning of the emoluments clauses remains unclear. Thank you, and I will be happy to answer any questions at the appropriate time.
Thank you very much. We'll now go to Mr. Von Spakowski.
Thank you, Madam Chairwoman. It's important to note that the lease between the government and Trump Old Post Office LLC, a corporate entity, not the president, became operative more than 3 years before Donald Trump was elected. The IG comes to a number of erroneous conclusions. The IG claims that GSA should have considered whether the lease is a violation of the Emoluments Clause, and that it failed to consider that issue when determining whether the leaseholder was in violation of Section 3719 of the lease. But the emoluments question is a constitutional issue under the authority of the Department of Justice, not GSA. DOJ has made it clear from the beginning of the administration and throughout the litigation filed against the president that the executive branch does not believe the lease violates the Emoluments Clause. That position is controlling for the entire executive branch, and the IG's criticism of GSA is therefore unwarranted. Furthermore, GSA's position that the tenant is not in violation of Section 3719 of the lease is also correct. That provision states that an elected official cannot be admitted to any share or part of the lease. But that section was not violated when the lease was entered into in 2013, since Donald Trump was not an elected official at the time. Also, the lease was not with him personally, but with a corporate entity in which he held a majority interest along with other shareholders. This section does not apply to Donald Trump, since it clearly states that it, quote, shall not be construed as extending to any person who may be a shareholder or other beneficial owner of a publicly held corporation or other entity. Trump Old Post Office LLC clearly falls within the definition of other entity. Trump's interest in this LLC, as you know, were transferred to a trust after he was sworn in. He relinquished his management control and announced that all profits from foreign government payments would be donated to the U.S. Treasury. Therefore, GSA was correct when it issued an estoppel certificate saying the tenant was in full compliance with the lease. It's also important to note that after interviewing 24 employees and reviewing over 10,000 documents, the IG found that there was no undue influence, pressure, or unwarranted involvement of any kind by anyone, including the executive office of the president. The IG's conclusion that GSA's unwillingness to address the constitutional emoluments issue affected its analysis of Section 3719 makes no sense, since it was and is the Justice Department's position that there's been no violation of the Emoluments Clause. There was and is no reason for GSA to independently consider the issue. The plain text of the Emoluments Clause, as well as historical practice, makes it clear that it was intended to prevent gifts, presents from foreign and state governments, as well as payments for services rendered in the president's official capacity. They were not meant to bar a president from having private business interests or owning businesses in which customers, including foreigners, pay the fair market value of products or services they receive in an open exchange. As DOJ has pointed out in its briefs, neither the text nor the history of the clauses shows they were intended to reach benefits arising from a president's private business pursuits having nothing to do with his office or personal service to a foreign power. The arguments advocated by those who say that the Emoluments Clause prevents anything of value being received by a president is far outside the intentions of the framers. Under that theory, the governor's pension that Ronald Reagan received as president would violate the Domestic Emoluments Clause. A DOJ opinion concluded that did not fit within the Emoluments Clause. Under this dubious theory, a president could not even hold U.S. Treasury bonds because the interest that he would receive in payments on those bonds would be considered a violation of the Emoluments Clause. The concerns raised by the IG have no basis in fact or law. There was no violation of the Emoluments Clause when the Trump Organization was selected to be the developer of the Trump Hotel in 2012. There was no violation after the president was elected based on the specious claim that any government official staying in the hotel is paying an emolument to the president. The president is not providing any services in his official capacity as president. Given that DOJ has maintained since the beginning of the administration that the lease is not in violation of the Emoluments Clause, there was no reason for GSA to consider that issue contrary to the criticisms of the IG. And the GSA was correct in its assessment of the lease. By its own terms, it does not apply to this situation. This is all much ado about nothing.
Thank you. Ms. Hempowitz.
Chair Titus, Ranking Member Meadows, and Chair DeFazio, and members of the subcommittee. Thank you for the opportunity to testify today on behalf of the Project on Government Oversight. At the root of it, we're here today because President Donald Trump has not fully divested from his private businesses, and his continued financial relationship with the Trump Organization creates a specific conflict of interest regarding the organization's lease with the GSA. This arrangement possibly implicates the Constitution's foreign and domestic emoluments clauses. It also presents a possible violation of the clause in the lease meant to ensure that government officials do not benefit from a lease of this sort. As we heard this morning, earlier this year, the GSA's Office of Inspector General found serious shortcomings in the agency's process of determining whether the Trump Organization was in compliance with the lease. Early on in the GSA's review, the agency's Office of General Counsel acknowledged that the President-elect's business interests in the Trump Organization might constitute a violation of the emoluments clauses. Such a violation could constitute a breach of the lease. Despite this knowledge, GSA officials did not consider this issue when determining compliance. Instead, GSA's review focused solely on whether Donald Trump's having been elected president constituted a violation of Section 37.19 in the lease. Based on a flawed legal analysis by the Trump Organization and a legal analysis by the agency's general counsel that has not been released to the public, the contracting officer determined there is no violation of this section. For example, in an effort to limit the scope of the section, the Trump Organization attorneys narrowly interpreted the word admitted. However, the definition they put forth plainly states that it could also mean give access to. Under this meaning, the assertion that the president was admitted to the lease before he was elected is unconvincing, as it doesn't address the fact that he can still access benefits from the lease. I know that members of the minority have expressed frustrations that the GSA-IG, in its review of the emoluments clauses, didn't definitively answer whether the president's interest in his private businesses constitute a violation of those clauses. But it appears that no one at GSA wants to be responsible for making that decision. When GSA's contracting officer determined that the Trump Organization was in full compliance with the lease, he knew of the existence of this possible violation and ignored it. This decision was made before litigation on the emoluments clauses began. This calls into question the prudence of his decision to issue an unqualified estoppel certificate to the Trump Organization. Even absent undue interference, serious questions remain about GSA's handling of this matter. Given the serious nature of the Inspector General's findings, the agency's response was grossly inadequate. Written by the agency's general counsel, the response ignored all but the Inspector General's one recommendation and placed the blame for the report's primary findings on former agency officials. The tone of the letter was at times jarringly contemptuous, appearing more concerned with protecting the president's reputation than ensuring the agency is operating in full accordance with the law. Ignoring the Inspector General's statement that it would not examine whether the president's interest in the hotel violates the emoluments clauses, the general counsel misstated that the Inspector General does not find any constitutional violation occurred. He further asserted that the Inspector General found an emoluments violation is merely possible, but disputes that claim, pointing to ongoing litigation in which the Justice Department is arguing that the president's business interests do not pose a violation of the emoluments clauses. The general counsel ignored the fact that in those lawsuits, Justice Department attorneys are exercising their role as the president's civil defense attorneys. The Federal Programs Branch of the Civil Division, as described on the department's website, defends civil actions against the Executive Office of the President, such as the Emoluments Clause lawsuits the General Counsel cited in his response. As the Justice Department is zealously arguing for an interpretation of the law most favorable to its client, it's hardly an impartial arbiter of fact or law in this situation. To present the department's assertions as impartial, like the GSA's General Counsel did in his response, is misleading. The conflicts of interest apparent in the lease for the old post office building may well be being managed appropriately, but it's inadequate and unfair to ask the public to blindly trust that an agency under the president's authority will manage those conflicts properly. Instead, the Trump Organization and the GSA should cooperate fully with oversight efforts of members of Congress. That oversight extends to examining the IG's review of the agency decision-making process. I'm therefore additionally concerned by a lack of productive response to a request for records from the GSA Inspector General submitted in part by Ranking Member Meadows. In closing, it's important for us to take a step back and consider the broader policy implications of our conversation today. The fundamental issue is whether we as a country are okay with a system that allows elected officials to privately profit off their official actions. If the answer to that question is no, as is suggested by the emoluments clauses in the Constitution, then we need to take a serious accounting of the laws and policies governing the conduct of those elected officials to ensure that they are sufficient. In this committee, that starts with GSA contracts. Thank you very much. I look forward to your questions.
Thank you. Mr. Shaw?
Chair Titus, Ranking Member Meadows, and members of the subcommittee, thank you for inviting me to discuss GSA's management of the old post office, which the President's business leases from the government he leads. Nearly 3 years ago, Donald Trump declared that, quote, a president can't have a conflict of interest. But that's not right. A conflict of interest arises when any official's personal interests are at odds with a duty to the American people. True, presidents and vice presidents aren't covered by a law that prescribes criminal penalties for conflicts of interest, but this exemption isn't a perk of high office. Conflicts of interest endanger the fabric of our republic. The Justice Department and the Office of Government Ethics have advised presidents to act as though the law applied, and for the better part of 4 decades, they did. They took the kinds of measures their appointees took to prevent conflicts of interest. Now a federally owned landmark houses the Trump Hotel, which is patronized by individuals and groups with interests affected by the federal government. For example, T-Mobile infamously sent executives to stay at the hotel while it sought federal approval of a merger. Lobbyists, advocacy groups, businesses, nonprofits, and political candidates frequent the hotel. And why wouldn't they? White House staff and other appointees mingle there with influence seekers. The hotel is even frequented by members of Congress who are responsible for oversight of the executive branch. Crew has also tallied nearly 60 foreign governments visiting Trump properties. One diplomat suggested it would be, quote, rude to come to his city and say, I'm staying at your competitor. In fact, today a transcript was released that shows that the Ukrainian president was highlighting that he once stayed at a Trump hotel. Apparently, he seemed to think that that would ingratiate himself to the president. Bahrain, Kuwait, and the Philippines hosted major events at the hotel. The Romanian prime minister personally stayed there. The Saudi government has been one of the Trump organization's bigger customers, raising concerns about the kingdom's relationship with the administration. The consequence of these circumstances has been an unprecedented ethics crisis. This scandal-plagued administration has seen one appointee after another resign amid inquiries into their conduct, while others remain in government under the cloud of ethics concerns. For their part, GSA officials emphasized that aspects of their work occurred before the inauguration. They claim this meant that they weren't under any pressure. That defense ignores the very real risks they faced if they challenged the Trump organization's lease compliance. The election was over, they were about to get a whole new set of bosses, and every career official knew this. In fact, GSA was the lead agency for the presidential transition. Now, there are 2 main problems with GSA's March 2017 lease determination. First, GSA refused to even consider the Constitution's emoluments clauses. In failing to even consider them, GSA fell below the standard for agency action. Failing to consider an important aspect of a problem renders an agency action arbitrary and capricious. More importantly, GSA officials failed to fulfill their oath to support and defend the Constitution. Second, the lease makes clear that an elected official cannot be admitted to any part or share of the lease and cannot benefit from it. Rather than interpreting this contract language, GSA sidestepped the issue. The determination only recites steps taken by the Trump organization that create the illusion of separation from the president. The Trump organization said the president's share of hotel profits will sit in a capital account while he's in government, but this doesn't solve the problem. The money stays in a property he owns, and he'll benefit from any improvements they make with it. There's also nothing to stop it from coming back to him when he leaves government. GSA also noted that President Trump's assets are now an irrevocable trust, but the trust is meaningless. OGE has explained that putting assets in irrevocable trust does nothing to resolve a conflict of interest. I discuss these issues in more detail in my written testimony. In closing, I'll just emphasize that GSA needs to conduct a new evaluation of the lease, one that properly takes into account the emoluments clauses and the relevant contract language. And of course, the most effective way to avoid issues would be divestiture. Thank you again for inviting me, and I'm happy to answer questions today.
Thank you, Mr. Schaub. We'll now go to Chairman DeFazio for the first questions.
Thanks, Madam Chair. Ms. Hempowitz, gentleman sitting next to you said that because the Justice Department is defending the president in civil litigation, that this becomes a controlling opinion over employees of the government in the United States. Is that correct?
I believe he may have been talking about the Office of Legal Counsel as its opinions involve this issue ongoing. I'm unaware of any OLC opinion directly on this situation, although they are notoriously private.
And for it to be binding, it would have to be an official opinion not involved in pleadings in a civil lawsuit.
I think so, but I also think the problem is that when the GSA initially decided not to look into this issue, the Department of Justice wasn't involved in any ongoing litigation on it.
That's a very good point. I mean, GSA has its own counsel. They say, well, they certainly couldn't handle that. Why wouldn't they ask the Office of Legal Counsel for an opinion?
I think that's a great question, and I think the Inspector General report highlights an instance 20 years ago where they did exactly that when the question involved members of Congress rather than the president.
Yeah, Mr. Schaub, because you also talked about GSA and dereliction of duty and not asking that question. You want to expand on that a little bit? Mike, I don't think your mic's on, or get closer or something.
Sorry. Can you hear me now?
Yep.
They had a duty to consider the issue. First of all, they swore an oath to uphold and support the Constitution. Second of all, courts have ruled that an agency's failure to even consider an important issue renders its action arbitrary and capricious. So that means that they haven't done the basic thing that agencies do to evaluate a problem. They just simply punted. They decided not to address it.
Well, of course, we don't know what was in the general counsel's legal opinion, which led to the estoppel by the career employee who shortly after the election was corresponding with Ivanka Trump and saying this is all nonsense, there's nothing wrong with this lease, and by the way, I want to tell you about my trip to New York and let's have coffee. Is that normal behavior by a contracting officer of the government of the United States dealing with the daughter of and or ultimate beneficiary of this?
Yeah, that's not normal for any government official. I spent years of my career working with presidential nominees, and I never once asked any of them out to coffee.
I think there's a different attraction there for him, but this employee. Mr. Foster, I don't know if you can answer this or not, but again, the gentleman sitting next to you alleged that because the Department of Justice has made pleadings in a civil litigation case, that becomes a binding legal opinion upon employees of the United States government.
Thank you for your question. I can't speak to the legal impact of the Department of Justice's pleadings. I do agree that generally formal opinions of the Office of Legal Counsel within the Department of Justice are binding within the executive branch unless or until they're overruled by the Attorney General or the President.
Okay, thank you. All right, thank you, Madam Chair.
Mr. Meadows?
Thank you, Madam Chairman. Mr. Spikoski, in your prior work, I think you served as an attorney at DOJ, is that correct?
That is correct.
And so, given that history, can you maybe elaborate on the role of the DOJ lawsuits, and particularly, I guess, the one involving the constitutional interpretation?
The Justice Department is the lawyer for the executive branch, including independent agencies and executive branch agencies and agencies such as GSA.
And they put forth an opinion, is that correct?
They put forth all kinds of opinions. They certainly have a whole long string of opinions on the emoluments clauses. But the point here is that they don't take when they take a position in litigation that a particular federal issue is constitutional or unconstitutional, that is binding on the executive branch, including other agencies. I not only worked at the Justice Department, but I was a commissioner for 2 years at the Federal Election Commission. And when we had a case, for example, before the U.S. Supreme Court, even if I, as a commissioner, personally believed, or in my official capacity, that a particular statute was unconstitutional, it was the Solicitor General of the Justice Department that argued before the court and argued about its constitutionality. I had no power to change that. So this idea that GSA can come up with its own view on the constitutionality of the Emoluments Clause, it just doesn't, it's just not in accord with the way the law has been practiced and the way the Justice Department operates. Just look back to former Attorney General Eric Holder, who refused to defend certain federal statutes, including those affecting gay marriage, because he said they were unconstitutional. The federal agencies involved with those particular statutes could not have appeared in court and said, oh, well, we disagree with the Attorney General.
So what you're saying is it would break historical precedents in terms of the executive branch to allow the GSA administrator here, I guess the ranking official that's been here and on the panel before you, who is not an attorney, to opine on the constitutionality of the Emoluments Clause. Is that correct?
He can opine all he wants, but his opinion is irrelevant, as is the opinion of the IG. The controlling authority is the U.S. Department of Justice.
All right, and so Ms. Himpowitz, is that correct? Let me come to you. I want to clarify one thing, and I see they've called votes, so I'll try to be very brief here. In your written testimony on page 4, you say the courts have adopted a broad definition of the emolument as any benefit, gain, or advantage, comma, including profits from private market transactions. I'm not aware of any case that would identify private market transactions. Can you help me with the case that was decided where that definition was included? Was that in a majority opinion?
Unfortunately, I can't off the top of my head, but I will tell you that the citation.
I don't think there is one.
The CRS
And so here I would ask you to clarify that, because I don't think there is one. We've looked, and when you look at it, it seems like, and you made a definitive statement, so perhaps you can go back and verify that, either get us the citation or remove it, and that would be very helpful.
I'd be happy to.
All right, thank you. Mr. Foster, let me come back to you in the 1 minute and 12 seconds I have remaining. CRS, I'm a big fan, and in fact, I applaud the Democrats for continuing to have CRS come as witnesses. I think it's good in a bipartisan spirit of transparency. Has the opinion on the Emoluments Clause, has it changed over time? Has what CRS interpreted as the emoluments, has it changed over time? And I know you're new, and so if you don't know, don't answer.
Thank you for your question. I think what I would say is that CRS's determinations are based in the law and are based in kind of existing legal precedent, and there's very little legal precedent on the question of what an emolument is. It has only recently been addressed by the federal courts.
So what you're saying is that basically we need, for CRS to have a definitive opinion, we probably need the courts to rule on this with the pending litigation that is out there?
There are ways that CRS can look at legal provisions that haven't been definitively interpreted and apply existing.
But you have, and that's changed over time. From 2012 to 2016, it's changed in terms of your interpretation from CRS. Are you aware of that?
I'm not aware.
I'll let you, I see your staff over there. I'll let you get with them and you can get back with us, and I yield back.
Mr. Foster, we keep hearing we heard from the GSA that they were trying to make the new practice consistent with underlying law, and they quote 8 U.S.C. Section 431, 41 U.S.C. Section 603A. That's a criminal provision and a civil provision that has to do with members of Congress and contracts. I would argue that that's not really relevant here, and I'm just asking you, do you think that supersedes the Constitution that prohibits a president or any elected official from taking emoluments?
Thank you for your question. I have not reviewed those provisions in preparation for this testimony. I can say as a general matter that, that statutory law does not supersede the Constitution.
Would you agree with that, Ms. Hempowitz?
Yes.
Thank you. Also, we've been hearing all from our friends down here how much money the post office is making now as a hotel. It's making all this money. It's great for the taxpayers, it's making all this money. Well, if it's making money, then it's making money for the president because it's a revocable trust, which he can revoke any time, or he can defer the money till he leaves office, or he can reinvest the money in the property. So he's making money. The hotel's making money. The president's making money. Mr. Schaub, isn't that a violation of the Emoluments Clause?
It certainly is. The revocable trust does absolutely nothing to separate him from his assets or his income. We dealt with revocable trust all the time with presidential appointees coming into government, and we helped them work through their conflicts of interest and consider these non-entities.
We also heard from the GSA and the IG that it used to be a best practice, that's their word, a best practice of the GSA to put something in the lease like Section 3719 that prohibits members of Congress or elected officials or members of the administration. If it was a best practice before President Trump came in, why isn't it a best practice now? Does that make any sense to you, Mr. Schaub?
Well, that's the most confounding thing about GSA's response. Their solution to this hard problem is to never address it again and eliminate this prophylactic conflicts of interest provision from future contracts. So they're compounding a dereliction of duty with an even bigger dereliction of duty.
And weren't you, Mr. Schaub, the director of the OGE when Donald Trump was elected? And didn't you give him some advice about how to avoid these conflicts of interest? Could you share with us that advice?
Well, I think I've been very public about the fact that all presidents should divest their conflicting financial interests, and the same is true for the current president.
Did he follow your advice?
He did not.
No, he didn't. Well, thank you all very much. We're going to have to go and, oh, where'd she come from? All right, sorry. We now have a new member with us. We'll hear from Ms. Miller.
Thank you, Madam Chairwoman. I want to thank you all for being here. And once again, I want to emphasize that the very first hearing that we had on this committee was called "The Cost of Doing Nothing: Why Investing in Our Nation's Infrastructure Matters." It's more important to my constituents that we act swiftly to improve our nation's infrastructure. Mr. Spikoski, how appropriate is it for a contractor to make a determination based on an unsettled law in the courts?
Well, I think that's very problematic for a federal agency, and I can say that as a former commissioner of a federal agency, and in particular, when the Justice Department is taking a position, again, because they are the controlling authority, particularly on constitutional issues, GSA can't go against that. And the position of the Justice Department throughout all of the litigation over the Trump Hotel and the lease is that this is not a violation of the Emoluments Clause.
Thank you very much. I yield back my time to Mr. Meadows.
I just want to thank all of you. I want to thank the gentlewoman from West Virginia, and I want to thank the chairman, and I'll yield back.
Thank you, Mr. Meadows. Any further questions from the subcommittee? Seeing none, I'd like to thank each of the witnesses for your testimony today. Your contribution to our discussion has been very informative, very helpful. I would ask unanimous consent that the record of today's hearing remain open until such time as our witnesses have provided answers to any questions that may be submitted to them in writing. And unanimous consent that the record remain open for 15 days for any additional comments and information submitted by members or witnesses to be included in the record of today's hearing. Without objection, so ordered. If no other members have anything to add, the subcommittee stands adjourned. Thank you.